All right, before we begin with your next witness, I'll take a motion from you, Mr. Josie.
Thank you, Chair Mitchell. Public staff moves that the exhibits attached to the pre-filed direct testimony of witness Thomas be entered into the record and marked for identification as pre-marked. There are 7 exhibits and Exhibit 6 is confidential.
All right, that motion will be allowed and the confidential information will be reflected as confidential in the transcript. All right, you may call your next witness.
Public staff calls Jay Lucas to the stand.
All right, good morning, Mr. Lucas. If you would, raise your right hand, left hand on the Bible, please, sir. Do you swear testimony about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, go ahead, Mr. Josie.
Please state your name, position, and business address for the record.
I'm Jay Lucas. I'm the manager of electric operations and planning in the Public Staff's Energy Division. My address is 430 North Salisbury Street in Raleigh, North Carolina.
And did you cause to be pre-filed in this docket on or about March 27th, 2023, direct testimony and question and answer form consisting of 28 pages, 1 appendix, and 7 exhibits?
Yes.
On May 4th, 2023, did you cause to be filed corrections to your pre-filed direct testimony?
Yes.
Also on May 4th, 2023, did you cause to be filed a summary of your direct testimony?
Yes.
And if I were to ask you those same questions today, would your answers be the same?
Yes.
Chair Mitchell, I request that Mr. Lucas's pre-filed direct testimony with corrections and summary of his direct testimony be copied into the record as if given orally from the stand, as exhibits be marked for identification as pre-filed.
All right, that motion is allowed.
Witnesses available for cross-examination.
All right, Fayetteville Public Works, you may proceed.
Good morning, Mr. Lucas.
Good morning.
I'm James West of the Fayetteville Public Works Commission. How are you?
Good.
I had a couple of what I hope are simple questions about your direct pre-file testimony. And in particular, I'd like you to turn to page 27, line 8. While you're looking, the testimony that I'm curious about is an assertion that the financial benefit of potentially delaying the retirement of the Mayo or Roxborough plants should not accrue solely to DEP. You see that?
Yes.
Can you explain in some detail what you mean by that?
I was concerned that if the commission allowed accelerated depreciation for those power plants, DEP collected more money sooner. And if those plants had retired sometime later than what was reflected in the depreciation rates, I was worried that DEP would have collected more of its money sooner, continued to operate the power plants after fully recovering them. This would have been to the detriment of customers. They would have paid too much too soon for those power plants if they were actually retired at some time after cost recovery.
And were you able to estimate what the detriment to customers would have been?
No, I didn't.
Under that scenario?
I didn't have a number for exactly what the detriment would have been.
Do you have an order of magnitude?
It'd be hard to, because it's not just the cost, it's the carrying cost of the money. I would have to take whatever time the plants did retire, because we don't know exactly. Those plants could go for 1 year after cost recovery, or they could continue to run for 5 or 6 years after cost recovery. I mean, it's highly variable.
Is it, were you at least able to estimate that the number was material?
Oh, yes.
Okay, so how do you define materiality for purposes of this assertion?
Well, I'm sure they've been in the millions of dollars. Probably have to go look at the depreciation study and take a look at it. The depreciation expenses are in the hundreds of millions of dollars, so the carrying cost, that if the plants, were retired early, retired late, it would have been in the millions of dollars. The customers, would have paid, and like I said earlier, the customers would have paid for the plants too soon.
So the second statement in your testimony that I had some questions about was the following sentence, which states DEP indicates in response to discovery that it has a plan to replace the capacity of Roxborough with hydrogen-enabled combustion turbines and combined cycle capacity, though its plan is not yet fully developed. And then the sentence after that, DEP has not provided any such general indication for replacing generating capacity of the Mayo plant. Do you see those two sentences?
Yes.
Did you, that information that you're citing came from discovery responses that DEP provided to the public staff during the discovery phase of this proceeding, correct?
Yes, that was public staff data request 171-2. It's not confidential.
Did you undertake your own investigation to any extent to either confirm or question Duke's statements in your testimony with regard to the discovery on lines 10 through 14?
No, I was asking Duke Energy Progress, just simply what its plans were. I mean, I was asked, it's not that the public staff was forming a plan. I was simply asking Duke Energy, what is your plan?
Understood, but once they provided the response, did you follow up with any of your own analysis to either validate what they were saying or to potentially undermine what they were saying?
No, I was not able to set any firm actual retirement dates, the date they turn the switch off. But in my testimony, I did come up with retirement dates for rate making purposes. There's a difference. So that was the heart of my testimony. What are we going to set for retirement dates for rate making purposes? But I would need to point out this has been resolved in the settlement.
Understood. Thank you. So let me focus very briefly then on the notion that Roxborough will be replaced with hydrogen-enabled combustion turbines and combined cycle capacity. Did you evaluate the likelihood that that statement is accurate in terms of being able to retire the Roxborough units by 2027?
I didn't have to really do an evaluation. I know it takes time for permitting, getting a certificate, engineering, planning, construction, everything it takes to build a new power plant, and also obtaining natural gas supply. So that's the statement I made. I believe that answers your question as to how my analysis was. I mean, just I know, learn from the certificate review, permitting review, that sort of thing. It's not quick to plan and build a power plant.
All right, so based upon your analysis prior to filing your pre-filed direct testimony, was it your opinion that replacing the Roxborough units 3 and 4 by 2027 with combustion turbines and combined cycle capacity was reasonable?
I knew it would be difficult. That was why I made that statement. And there's a risk that it could not happen. There could be all kinds of problems, permitting, natural gas supply. There are various things that can hold up a power plant, environmental review, those sort of things. So I knew that it'd be difficult for Duke Energy Progress to have those power plants ready by the time they had asked to retire them in the testimony of their witness, Spanos.
So with regard to the notion that the capacity was going to be replaced with hydrogen-enabled combustion turbine and combined cycle capacity, is it your understanding that the hydrogen-enabled combustion turbines and combined cycle units are commercially viable at this point?
I don't know of any that are built and operating.
I have no further questions.
Good morning, Chair Mitchell. As I shared with the public staff over the weekend, my co-counsel who has previously entered an appearance in this docket, Chris Edwards, is here with me and may, with your permission, also potentially ask Mr. Lucas some questions this morning. And as I understand it, the public staff has two lawyers defending Mr. Lucas as well, which SIGFR is fine with, of course, with your permission. Thank you. Good morning, Mr. Lucas. First, I want to speak with you about the genesis of the equal percentage bill increase or decrease method of allocating fuel costs, which I'm going to refer to this morning throughout my questioning as the equal percentage method. Mr. Lucas, I understand that the equal percentage method originated from a stipulation between the public staff, DEP's predecessor company, SIGFR 2 and KUKA in docket number E-2 sub 929 back in 2008. Is that correct?
Yes,
I'm going to ask you, please, sir, to turn with me to what has been pre-marked as SIGFR 2 potential cross exhibit number 20. You should have a binder up there that has SIGFR 2 potential cross exhibit number 20.
yeah, I've got it.
Okay, could you turn with me to tab 20? And Chair Mitchell, I'll go ahead and ask that this document be identified as SIGFR 2 cross-examination Lucas Direct Exhibit number 1.
All right, the document will be marked as SIGFR 2 cross-examination Lucas Direct Exhibit 1.
Thank you. And this is the sub 929 settlement. Is that right, Mr. Lucas?
Yes.
And this settlement was approved by this commission. Is that your understanding?
For the most part, the pertinent parts we're talking about, the commission did accept. They didn't accept the whole thing, but I don't think that's really relevant to what we're going to discuss today.
Thank you for that. And Chair Mitchell, I'd request at this time that the commission take judicial notice of its order approving fuel charge adjustment issued on November 14th, 2008 in docket number E2 sub 929.
Repeat the date, Ms. Kress, please, ma'am.
November 14th, 2008.
All right. The commission will take judicial notice of its order as requested by council.
Thank you. Mr. Lucas, the equal percentage method has been in place as the approved fuel and fuel-related cost allocation methodology for DEP continuously since 2008. Is that correct?
That's correct, but that had to change because of House Bill 951 and the requirement to eliminate cross subsidies.
And moving from 2008 to 2012, the equal percentage method was later proposed by Duke Energy Carolinas, or DEC, and approved by the commission beginning in 2012. Is that right?
I can't remember the exact year, but somewhere one of the years back, DEC did start using the equal percentage method also.
Okay. And the equal percentage method, to the extent you know, has been in place as the approved fuel and fuel-related cost allocation methodology for DEC continuously since 2012.
That's correct.
Thank you. Mr. Lucas, I've got a copy of the sub 929 order located behind the tab for SIGFR 2 potential cross exhibit 26. If you could turn there with me, sir.
I'm there.
I'd like to turn your attention to finding of fact number 8 on page 4 of that order. Are you there on page 4?
Oh, here we go. Yes, I found it.
Okay, and finding of fact number 8 reads that, quote, "The uniform bill adjustment methodology proposed by DEP's predecessor company, Sigfer 2, KUKA, and the public staff is just and reasonable and should be approved for the purpose of this proceeding." Is that correct?
Yes, but I need to point out also in this order, the commission accepted the settlement, and part of that settlement agreement is, one thing the public staff wanted was spreading the costs out of this large fuel increase over a 3-year period. This was part of a package that was part of that settlement agreement.
Thank you for that. I want to talk with you a little bit about the mechanics of the fuel rider and this allocation methodology specifically. The rate tariffs for DEP include a base fuel component and a separate fuel adjustment clause charge. Is that right?
The base fuel sets are set in a rate case, and then there's an adjustment based upon the prospective period, and there's an adjustment for an EMF period. That looks into the past.
And what does EMF stand for?
Or experience modification factor.
Great, thank you. So there's 2 components of what is recovered through the fuel rider then, is that right?
Yes.
Great. So I'd like to ask you a few questions about the cost of service study that's been previously entered into the record as Sigfer 2, cross-examination, Metz McLawhorn, direct and settlement exhibit 1. It was pre-marked as Sigfer 2, potential cross-exhibit number 88. If you could find that binder, sir.
I'm there.
Great. Could you please turn with me to page 30 of that document? At the bottom of page 30, do you see the section that reads allocation of fuel costs?
Yes.
Could you please read for the record the first paragraph underneath allocation of fuel costs?
I need to point out, I'm not the cost of service witness. I'm only talking about equal percentage fuel adjustments.
Could you please read the
Okay,
first
I can read
paragraph?
it. Fuel costs are considered pass-through costs as they are passed on to customers on a dollar-for-dollar basis and do not include a return component. You want me to read the whole thing, or
I do, please.
Okay.
Thank you.
just tell me when to stop?
I sure will.
Okay.
Thanks.
The rate tariffs for both DEC and DEP include a base fuel component and a separate fuel adjustment clause charge. A fuel adjustment clause is a regulatory provision that permits a change in rates to occur because of a change in the cost of fuel or the variable portion of purchased power expenses. These changes occur without the utility filing a formal rate case. Rather, in North Carolina and South Carolina, the regulatory commissions conduct an annual fuel adjustment proceeding to adjust the fuel adjustment charge up or down as appropriate. These smaller focused proceedings are designed to eliminate the lag between changes in fuel costs and the reflection of those charges in rates. Thus, a fuel adjustment clause acts as an interim measure for adjusting rates to reflect changes in a large and highly volatile expense item so that under-recovery or over-recovery of the expense does not lead to financial deterioration or excess profits for the utility.
You can stop there. Thank you. And if you could turn with me to the next page, page 32. Do you see that the last sentence of the first full paragraph on page 32 reads, "If the variation in hourly fuel costs is substantial, high load factor customers will be allocated a disproportionate share of those fuel costs"?
Well, that's taken out of context. we'd have to go through this because it's, I would have to see everything that leads up to that sentence. I can't agree with that sentence is just taken out of context. I would have to go through this document. I haven't seen it.
So, Mr. Lucas, just to confirm, you've never seen the cost of service study
No, I haven't.
document that you're looking at?
No, I haven't.
Were you not involved in the cost of service study stakeholder group?
No, I wasn't.
So now let's turn to your testimony that you filed in this rate case. If you could turn with me to page 17.
I'm there.
Okay, you state on page 17, lines 5 through 6 of your testimony that DEP is justified charging less per kilowatt hour for certain customer classes that receive service at higher voltages. Is that right?
That's correct, because taking service at a higher voltage results in less fuel being burned at the power plant. Higher voltage has less resistance than lower voltage, so it requires less fuel to provide the same kilowatt hour.
Thank you for that. And you testify on the bottom of page 19. Continuing through the top of page 20, that fuel costs are incurred based on the cost of fuel used to produce a kilowatt hour of energy. Do you see that?
Yes,
And you also state on page 21 of your testimony that fuel cost allocations should be based on the fuel usage required to provide energy to customers. Is that correct?
I'm sorry, what lines are you on? Page 21.
Lines 7 and 8. 6 through 8, rather.
That's correct.
It's true, is it not, that some costs recovered through fuel rates are not incurred based on the cost of fuel used to produce a kilowatt hour of energy?
That's correct.
At this time, Chair Mitchell, I'd ask that the commission take judicial notice of North Carolina General Statute 62-133.2 and Commission Rule R855.
Commission will take judicial notice of statute and the rule as requested by council.
Thank you. To get a little bit more into the specifics there, Mr. Lucas, are certain capital costs and capacity costs and transmission costs associated with purchase power recovered through the fuel rider?
I don't know about transmission costs. Payments for kilowatt hours from a renewable energy facility they do contain some capital costs.
That are recovered through the fuel rider?
Yes, and this is by state law.
Would you agree with me that those capital costs recovered through fuel charges are not being incurred based on the cost of fuel used to produce a kilowatt hour of energy?
That's true, but that's a small component of the fuel charges.
And we'll come back to that piece specifically, so thank you. Capacity costs in an approved DEP cost of service study are allocated using a demand factor, correct?
I don't do cost of service.
So is that a question I should ask your colleague, Mr. Williamson?
That's David Williamson, yes.
Okay. So do you know then, sir, if Duke Energy Progress were to build a new solar energy generating facility, would it be allocated using a production demand factor? Or is that also a question I need to ask your colleague?
Duke Energy were to build a solar facility, it'd be treated like any other generating plant. It'd be part of depreciation expense. Those costs would not be in the fuel rider.
Thank you. So turning back to the cost of service study, which I understand your testimony to be that you have not seen before today. Nevertheless, I have some questions for you because you are the fuel cost allocation witness, are you not?
Go ahead and
Log an objection to any questions dealing with the cost of service study. Again, this witness has said he's not the witness for cost of service. Furthermore, SIGPER has signed a settlement agreement on cost of service in this case, in which it waived cross-examination on that issue.
Chair Mitchell, to the extent that there are discussions in the cost of service study report, which has already been entered into evidence in this case, I think it is relevant and material to Mr. Lucas's testimony, which deals with fuel cost allocation, which was an issue that was not resolved by the settlement referenced by council.
All right, I'm going to overrule the objection. Allow council to ask her questions. I recognize Mr. Lucas has said he's not the cost of service expert and he hasn't reviewed the document prior to his time on the stand today. And so we will give his testimony the weight that it's due, but you may object to questions as she asks them if you have a sound basis for your objection.
Thank you.
Thank you. Mr. Lucas, do you have that in front of you?
Cost of service, yes. I don't want to warn you, my testimony is not everything there is to know about fuel. I focused on equal percentage fuel adjustments. So some of this may be brand new to me. We'll have to see.
Understood, and thank you for that. If you could turn to page 7, please.
And this is still tab 88.
Yes, sir.
Okay, I'm there.
Do you see the last sentence? And it starts on the previous page at the bottom of page 6. Do you see the last sentence of subsection 2 there states, for purposes of these studies, all demand and customer classified costs can be designated as fixed and all energy classified costs can be designated as variable?
I'm sorry, you're at the bottom of page 6.
Right, so number 2 starts at the bottom of page 6 and continues on to page 7, and
Yes,
I'm
starts with-
asking specifically about the last sentence in section 2.
And the last word that begins with the word "the" and then jumps to the next page, or the previous sentence.
The sentence that reads, for purposes of these studies, all demand and customer classified costs can be designated as fixed and all energy classified costs can be designated as variable.
Okay, that begins, well, my copy's different, I guess. This is at the top of page 7, the first complete sentence. It says, for purposes of these studies, all demand and customer classified costs can be designated as fixed, and all energy classified costs can be designated as variable.
Thank you. Did you hear Mr. McLawhorn's testimony provided in this case?
Yes,
And Mr. McLawhorn testified that if DEP purchases solar capacity, it's allocated on an energy basis and recovered through the fuel rider. Is that right?
that's correct. Because one thing about solar facilities, you can't just say, we're going to pay you a capacity payment because it's a 5 megawatt solar facility. Its output's variable. It's not dependable capacity. And this is true for all renewable energy facilities. They're all paid for kilowatt hours. They get paid more during peak demand for those kilowatt hours, and that sort of acts like a capacity payment. Like I said, solar facilities and other renewables, they're not paid a capacity payment based upon their nameplate capacity. They're all paid in kilowatt hours. They just earn more during peak time kilowatt hours, and that's, in effect, acts like a capacity payment.
Do you consider energy generated by a solar energy facility to be fuel?
Yeah, this fuels the sun, created by the sun.
So that's your testimony that you consider solar power to be fuel?
No, solar power is not fuel. The fuel is the sun. Okay, go back to the physics. The photons come from the sun, hit a solar panel. There's a reaction that photons start pushing electrons through a wire. We've got a general statute that says, well, it's going to be a fuel-related cost. And that's why we cover those costs in the fuel rider.
Do you acknowledge anywhere in your testimony or your accompanying exhibits that there are several fixed costs recovered through the fuel rider?
No, they're not really fixed, because if a solar panel system is not putting out energy, they're not getting paid. It's not a fixed cost. It's not like if a solar panel system breaks for a whole year, they can't come back in and say, well, I should get fixed costs anyway because it costs me to run this solar panel system. If they don't make kilowatt hours, they don't get paid. They're only paid for kilowatt hours. And like I said earlier, that's variable. That kind of acts like a capacity payment.
And sir, you previously testified this morning that certain capacity costs and certain capital costs are recovered through the fuel rider.
Because this, the solar developer does have capacity requirements to build his capacity, but he's not paid, or they're not paid based on any kind of capacity. They're only paid for kilowatt hours.
To your knowledge, has the public staff done any analysis to determine whether or by how much the proportion of non-fuel costs recovered through the fuel rider will increase this decade as the result of implementing the carbon plan?
Not to my knowledge.
Did you hear your colleague, Mr. McLaughlin, acknowledge that the non-fuel components of costs recovered through the fuel rider are likely going to increase as we look toward 2030 with carbon plan implementation?
I don't remember that exact statement.
Okay. Do you recall that Mr. McLaughlin also made the point that fuel costs are expected to go down as non-fuel costs are expected to increase?
I just can't remember any of his exact statements.
Okay. All right. Shifting gears then, it's your testimony, correct, that the equal percentage method shifts costs from the LGS class to other customer classes? Is that right?
No, that's not correct. The cost shift created by equal percentage fuel adjustments can shift costs from residential customers to industrial customers or vice versa. It's not any one customer class will receive all benefits or all harm by the equal percentage fuel adjustment.
Okay. But this distortion, to use your word, is symmetrical in that the opposite is true as well, meaning that in times of fuel decreases, more of the decrease would flow back to the residential class than it does to, say, the LGS class. Is that right?
Can you point to where that is in my testimony?
The word distortion?
Well, your whole statement about shifting your whole question.
So this is a question for you that is not based on your testimony. This is a question I'm asking that I would like for you to answer on the stand, please.
Okay, sure.
So this distortion that you allege occurs is symmetrical, is it not? And that the opposite is true, that in times of fuel decreases, more of the decrease flows back to the residential class than it does to, say, the LGS class.
It is definitely not symmetrical. Fuel prices are not in some kind of perfect rhythm where customer classes are fairly treated, say at the end of a decade. We want fuel costs to be fair each and every year. And it's true with declining or inclining fuel costs that one customer class may take advantage of another, but it's not symmetrical. Like I said, fuel prices, look back, they almost seem erratic. It's not like at the end of a period of years that all customer classes are made whole. We don't true up fuel costs that way. Also, there's never any true up for the time value of money. If one customer class is harmed by this equal percentage fuel adjustment, it's not like they're made whole a few years later if fuel costs go the other way.
At this time, I'd like to turn your attention to public staff potential redirect exhibit 137. And Chair Mitchell, I'd request that this document be marked for identification as Sigford 2 cross-examination Lucas Direct Exhibit 2.
All right, the document will be marked as requested by council.
Thank you. Are
I'm
you,
there, I'm there.
can you please read the response DEP provided to this data request from the public staff number 187-4?
Just read the response itself.
Yes, sir.
Okay. Because the equal percent method aims to achieve a uniform total bill impact among all customer classes in an environment of rising cost, the cost increase is shifted to the residential customer class and away from the large and medium general service customer classes. Respectively, in an environment of declining costs, the cost benefit is also shifted to the residential customer class and away from the large and medium general service customer classes.
Thank you. Turning back to your testimony, you testify, and I'll let you get there. It's page 20.
I'm there.
I'm not, so if you give me one moment.
No problem.
You testify on page 20 that you've had the opportunity to review the 14 DEP fuel proceedings that followed the sub 929 docket. Is that correct?
That's correct.
Okay, so you would acknowledge, subject to check, that DEP had fuel decreases in docket number E2 subs 1069, 1107, 1204, 1250, and 1272, correct?
I would have to check that, but subject to check, I would agree.
Thank you. Chair Mitchell, because the witness has testified about his review of these 14 previous proceedings and the way that his review has informed his recommendation in this proceeding to this commission, we would ask that the commission take judicial notice of its orders in each of those subsequent 14 proceedings. And I have them all listed here and happy to go through them either one at a time or all in one fell swoop, however you would prefer.
All right, the commission will take judicial notice of its orders, but let's identify each of those orders with specificity at this time for purposes of the record and
Thank you, Chair Mitchell. Order approving fuel charge adjustment in docket number E2 sub 949 issued on November 16th, 2009. Order approving fuel charge adjustment in docket number E2 sub 976 issued on November 17th, 2010. Order approving fuel charge adjustment in docket number E2 sub 1001 issued on November 14th, 2011. Order approving riders in docket number E2 sub 998 issued on August 12th, 2012. Order approving fuel charge adjustment in docket number E2 sub 1018 issued on November 16th, 2012. Order approving fuel charge adjustment in docket number E2 sub 1031 issued on November 25th, 2013. Order approving fuel charge adjustment in docket number E2 sub 1045 issued on November 19th, 2014. Order approving fuel charge adjustment in docket number E2 sub 1069 issued on November 9th, 2015. Order approving fuel charge adjustment in docket number E2 sub 1107 issued on November 7th, 2016. Order approving fuel charge adjustment in docket number E2 sub 1146 issued on November 17th, 2017. Order approving fuel charge adjustment in docket number E2 sub 1173 issued on November 8th, 2018. Order approving interim fuel charge adjustment requiring further testimony and scheduling hearing in docket number E2 sub 1204 issued on November 25th, 2019. Order approving fuel charge adjustment in docket number E2 sub 1250 issued on November 30th, 2020. Order approving fuel charge adjustment in docket number E2 sub 1272 issued on November 17th, 2021. And order approving fuel charge adjustment in docket number E2 sub 1292 issued on November 3rd, 2022.
all right, Ms. Kress, go back and check for 2011 and 2012. Can you go back and identify those orders with specificity? Because I've got my notes have the sub dockets a bit out of order and the dates seemed off to me too. So just make sure and it may be that something strange was happening in those years, but can you go back and make sure you've got you've got those orders identified correctly?
Absolutely. And you said 2011 and 12?
Yes, I have
Okay.
two, yes, 2011 and 2012.
Order approving fuel charge adjustment in docket number E2 sub 1001 issued on November 14th, 2011. Order approving riders in docket number E2 sub 998 issued on August 20th, 2012. And order approving fuel charge adjustment in docket number E2 sub 1018 issued on November 16th, 2012.
Okay. Reread the order caption for the order that was issued in sub 998.
Order approving riders.
Okay, all right, let's proceed.
Thank you, Chair Mitchell. Mr. Lucas, would you agree with me that before supply chain issues arising during COVID and the war in Europe, fuel costs were going down?
Well, let me check. I've got a graph of natural gas prices here from 1998 to the present. Like I said earlier, they're kind of erratic, but it looks like a period from like 2019 to 2020. It looks like natural gas prices were generally going down.
Thank you. And would you agree with me that coal and natural gas prices have increased significantly in recent years?
Yeah, from 2020 to 2022, natural gas prices declined significantly. Just the past few months, they've gone way back down. And coal prices did generally go up. I don't have that information in front of me. We don't burn so much coal as we used to.
Thank you. I'd like to turn your attention now to what was pre-marked as Lucas Exhibit 7.
Is it an exhibit from my testimony? Or?
Yes, sir.
Okay. Okay, I'm there.
And now first, this document is labeled as Public Staff Lucas Exhibit 7. Is that right?
That's correct.
Is there any other label for it?
I don't have another label unless it was put in as a redirect exhibit or something.
Okay. The listed fuel rates that you have in the small table at the top left of this exhibit, those rates do not include the EMF increment, do they?
No, they don't include the EMF.
So in other words, the rates listed in your small tables at the top of this exhibit are not based on the total net fuel and fuel-related cost factors, are they?
No, that's from two different fuel years, 2021 and 2022. And there's DEP fuel cases, sub 1272 and sub 1292. Those are base fuel rates, and the adjustment as if there had not been equal percentage fuel adjustment.
And to be clear, for the record, the rates that you have listed in these tables do not include the EMF component of the fuel rider rates, correct?
Well, what are you talking about? Those two small tables, we talked about those. Those are just base fuel rates and the adjustment for the prospective period. The two tables below that, first one is kilowatt hour sales, and the next two are fuel revenues.
Okay, so let me try asking this one more time since you haven't given me the yes or no answer that I'm seeking.
Okay.
Do these two tables in the top left-hand corner of this exhibit include the EMF component of the fuel rates?
No, they don't.
Thank you. Do your numbers here assume that fuel costs are the same for every hour?
No, it's just fuel costs for each month, the total for each month.
Okay. Do your numbers take into account that high load factor LGS customers use more power in off-peak periods when fuel costs are lower?
No, we don't allocate fuel costs or power plant production that way. We don't assign certain fuels to certain customer classes, and we don't assign certain power plants to any particular customer class.
Did you remove all non-fuel costs in this analysis, such as capacity costs, chemical costs, transmission costs, profits included in purchase power, losses from sales of coal ash, or transportation costs?
No, and this would be the last two large tables. This is just fuel revenues total.
Shouldn't you remove all non-fuel costs to make your analysis valid?
No, these are fuel revenues, and fuel revenues are part of what's used to do the equal percentage fuel adjustment.
Thank you. Do your numbers in the bottom left-hand corner of this exhibit represent what you contend to be the cost shift resulting from the equal percentage method?
Yes,
If you had used the total net fuel and fuel-related cost factors, meaning both the base and the EMF component of 2.527 cents per kilowatt hour for LGS customers, your calculations here would have been smaller numbers, isn't that right?
I would object to this question unless she has some evidence of the calculation.
Chair Mitchell, this exhibit, as I understand it, is a result of calculations that Mr. Lucas has performed, and I am asking a question about what would happen if he tweaked the calculations that he has made here and as reflected in this exhibit that is attached to his testimony.
this is a complicated table. I mean, I can't.
And Mr. Lucas, let me address the objection first. And Mr. Josie, can you respond to Ms.
I
Brown?
would say it's a complicated table, it's a complicated calculation, and for it to be made a tweak is, I think, oversimplifying what is actually happening here.
All right, I'm gonna overrule the objection. Mr. Lucas, just do your best here and help us understand if you can. Respond to her question and help us understand whatever limitations there may be with respect to your response.
Mr. Lucas, do you need me to restate the question?
Yes, please.
Okay, if you had used the total net fuel and fuel-related cost factors, meaning both the base plus the EMF of 2.52 cents per kilowatt hour for LGS customers, your calculations of what you contend to be the cost shift would be smaller numbers. Is that right?
I can't testify to that. I would have to go through this spreadsheet again.
So just to make sure I understand your position, the public staff is proposing an alternative allocation in fuel rates that would eliminate what it contends to be the alleged interclass cross subsidy in fuel rates. Is that right?
That's correct, and we have to now because of House Bill 951 now requires us to set rates based on cost causation principles.
So even if we assume for sake of argument that these numbers here in the bottom left-hand corner of your Exhibit 7 are the actual cost shift resulting from the equal percentage method, you acknowledge, do you not, that the roughly $5 million that you contend is under-collected from the LGS class is a little less than 1/9 of the $43 million annual subsidy during rate year 0 being provided by LGS customers to other customer classes?
I'm sorry, I'm not testifying on particular rate year 0 or the year in this case. It's millions of dollars. It's a cross subsidy. Now we're required by law to fix it. So that's what we're doing, regardless of the dollar amount.
So just to make sure I understood your testimony correctly, are you recommending single issue rate making?
No.
How is this not single issue rate making?
Well, we found a potential problem and we were trying to fix it. There were lots of expenses in the rate case that we adjust. I mean, this isn't single issue. This is a rate case. We had a settlement with over 30 issues. It's not picking out one issue. We've found a problem. We're required by law to fix it. It doesn't matter if it was 20 problems or one problem. We're going to fix it.
And so just to be clear, the $43 million interclass cross subsidy from LGS customers to other customer classes is only being recommended by the public staff, in this case, to be reduced by 10%. Is that right?
I'm sorry, where'd you get the $43 million from?
Reed, DEP witness Reed, Exhibit 4 to her testimony. Do you have that in front of you?
No, is it available?
If you can turn to SIG for 2 potential cross exhibit number 70. And we might be able to speed things up a little bit here if you would just agree, subject to check, that DEP witness Reed testified to this interclass cross subsidy and base rates.
And I would object. I think he is not the rates witness.
I can't testify. I mean, this,
Mr. Lucas, let me address the objection first. I'm going to overrule the objection and go ahead and please provide your response.
can you please restate your question?
Sure. So you said that this alleged cost shift here in your bottom left Exhibit 7 is something that needs to be eliminated because of House Bill 951. And so my question to you is, shouldn't the $43 million annual subsidy that LGS customers are providing to other customer classes in base rates also be eliminated?
I'm not the cost of service witness. Like I said earlier, my testimony is only about equal percentage fuel adjustments. I can make statements about other items and rates or other cross subsidies.
So your testimony is limited to this single issue of fuel cost allocation.
That part of my testimony is I testified a lot of things, coal ash, plant retirement. If you add up all the other public staff testimony, we had lots and lots and lots of issues in this rate case, but I have one particular item we need to correct because of state law now.
But your recommendation pertaining to cross subsidization is based on the single issue of fuel rates, correct?
Or equal percentage fuel adjustments.
So is that a yes?
Yeah, that applies to fuel rates, yes.
I'd like to turn your attention to what's been pre-marked as Lucas Direct Exhibit 6. And this is labeled as a draft. Is the public staff planning on revising this at a later date?
You better get some things out of the way here. Okay, you're exhibit 6 of my testimony.
Yes, sir. And do you see here it says draft, not a component of the 2022 DEP NC fuel filing? My question is this document a draft, or is the public staff planning on revising this at some point?
No, Those are Duke's words. We asked Duke Energy Progress to provide calculations of fuel rates without equal percentage adjustments. Since we were reviewing fuel cases, they just didn't want confusion between the spreadsheet and what was actually in fuel rates.
And Harrington is not a witness in this rate case, correct?
No, she was a witness in the previous DEP fuel case.
And so your Exhibit 6, just so I understand it, is an altered version of an exhibit that was filed in a different docket?
That's correct.
And I see you have this box around one line of numbers, but to be clear, that's not the only alteration that was made from the original version of this document, correct?
Yes, the fuel calculations are a spreadsheet. It's got about 38 tabs that are all linked together. So there are lots of numbers that flow from one spreadsheet to another.
And you haven't included a red line version of the original exhibit to show what was modified from the original version, correct?
No, that'd be lots of spreadsheets, but no, I haven't provided that.
And you also haven't included the original Harrington Exhibit 1 in that other docket as an exhibit to your testimony, have you?
No, but it's in the record in E-2 sub 1292.
That's not this rate case, correct?
That's correct.
Okay, Chair Mitchell, at this time, Sigford 2 would object to the admission of Lucas Exhibit 1 and further move to strike it from the record for failure to authenticate it. Mr. Lucas has provided neither the original Harrington Exhibit 1 nor a red line version of the original, meaning there is nothing in this record, in this docket, to show what changes have been made, nor the directionality or materiality of those changes. And as we've previously established in this proceeding, it's not proper to take judicial notice of a party's filing in another docket. Finally, it would constitute rebuttal or surrebuttal evidence to allow counsel for public staff to now, at this stage in the proceeding, lay the proper foundation to authenticate this exhibit during live redirect examination. So for all these reasons, Lucas Direct Exhibit 6 is improper, inadmissible, and should be stricken from the record.
All right, Ms. Kress, just so the record is clear, your motion pertains to Lucas Exhibit 6, to his pre-filed testimony.
That's right.
Exhibit 6, okay. Mr. Josie?
I would say that this is an illustrative exhibit. Ms. Kress has asked Mr. Lucas numerous times to, accept things subject to check, including a spreadsheet change in just a minute ago, and to not allow this after allowing that, I think would be improper.
Chair Mitchell, these are, with all due respect, these are not analogous things. We're talking about a spreadsheet where numerous changes were made to these numbers, and there's nothing in this record to show what was changed and by how much. And so it's illustrative of what without something to compare it to. It's improper.
I do show how much.
All right, Mr. Lucas, let me let your attorney respond to counsel. Mr. Josie, anything else to add here?
Again, I would just say that this is to show what the calculations he did. And if Ms. Kress would like us to, or the commission would like us to file a late filed exhibit supporting that, we can. However, again, we have been through this once with a different spreadsheet on a different line of questioning.
All right, I'm going to overrule the objection. We'll give the evidence the way that it's due.
Thank you, Chair Mitchell. Turning back to your testimony, you testify at the.
I'm sorry, let me be clear for the record here. I'm gonna deny the motion. I'm gonna deny the motions made by SIG for counsel, and we will give the evidence the way that it's due.
You testify at the bottom of page 24. That DEP should implement the public staff's recommended base fuel rates for the prospective period in its next fuel proceeding to be filed in June 2023, with rates taking effect on December 1st, 2023. Is that right?
That's correct.
Has the public staff quantified what the impact will be on the different customer classes in that upcoming DEP fuel rider proceeding in the event this commission were to adopt the public staff's recommendation in this case?
We can't because DEP hasn't filed it yet. We don't know exactly what kind of prospective period costs DEP will provide. We don't know what kind of experience modification factor DEP is going to provide. We'll have to review that case and make that decision later.
How can this commission ensure that the LGS class of customers won't be unreasonably harmed if it were to adopt the public staff's recommendation in this rate case regarding a future fuel rider proceeding that hasn't been filed yet?
Well, that's the purpose of my testimony. We're trying to make sure no customer class is unreasonably harmed. You think right now, under equal percentage fuel adjustments, that one customer class can take advantage of another one. And we'll have recommendations, and the commission will have to decide on the evidence of the case provided by the public staff, provided by DEP and other interveners, and make a decision and, excuse me, make fair rates.
So if one customer class was taking advantage, as to use your words, of another customer class or other classes of customers in base rates, would you also say that that should be fixed and addressed by this commission?
I can't testify other than what's in my equal percentage fuel adjustments.
So back to that whole single issue rate making thing.
There's not single issue rate making. We've found a problem that we're required by law to fix. So in equal percentage fuel adjustments, we're fixing a cross subsidization by law.
Would you also say that you are required by law to fix a cross subsidy in base rates?
I'm going
I
to
think to-
object again. This is asked and answered.
Going to overrule the objection. Mr. Lukes, answer the question, please, sir.
Yeah, I'm not testifying anything else in base rates other than this fuel percent adjustment. I'm not a lawyer, and I can't say exactly how that law has to apply across the entire rate case.
Well, you're testifying pretty confidently that this alleged cross subsidy should be eliminated with respect to the fuel rider, but is it your testimony that that same cross subsidy should not be eliminated in base rates?
That's my testimony. I'm not saying it should or should not be. I'm not making a statement about anything else in base rates other than this equal percentage fuel adjustment.
Okay, so your testimony in this case is limited solely to fuel costs
The equal percentage adjustment component of fuel costs.
without considering whether there might be an existing interclass subsidy from the LGS class to other customers in base rates.
Again, objection, asked and answered.
I'm going to overrule, ask the question one more time, and Mr. Lucas answer it.
Mr. Lucas, does your testimony in this case pertaining to the equal percentage method take into account that there is an existing interclass subsidy in base rates from the LGS class to other customer classes?
Your question is mixed with a statement. You have the statement that there are other cross subsidies. I did not review any other type of cross subsidies, but I'm not making any other statements about cross subsidies except this equal percentage fuel adjustment.
How can the commission ensure, if it were to adopt the public staff's recommendation in this case, that elimination of the equal percentage method wouldn't constitute rate shock for the LGS class of customers in a future fuel rider proceeding that hasn't been filed yet?
Oh, well, all customers can be exposed to rate shock at fuels. We can't guarantee no one will.
How can this commission ensure specifically for the LGS class of customers pursuant to the allocation change you're recommending in this case?
Well, there are various ways, spreading fuel costs over 3 years, like Commission did in E-2 sub 929. There are other ways to mitigate fuel rate shocks.
Has DEP indicated that it's willing to spread its fuel costs over 3 years?
No, we're not in a DEP fuel case proceeding right now. That we'd have to see what DEP requests this coming June.
DEC has filed its 2023 annual fuel rider application, and its $1 billion under recovery has already been testified to in this rate case by your colleague, Mr. McLaughlin. Did you hear that testimony?
I don't remember specifically about what he said, but DEC in its original filing did request about $1 billion under recovery collection.
Are you aware that the equal percentage method in DEC's pending fuel rider proceeding will result in an approximately 18% total bill increase across customer classes in that docket?
I believe the total cost, I think the average total cost for an increase was about 18% for all, averaged among all customer classes.
Has the public staff calculated what the percentage increase would be for DEC's large industrial customers without the equal percentage method?
No, we have not. But we're not recommending to eliminate equal percentage fuel adjustments in the current DEC rate case. I recommend if the commission adopts the elimination of equal percentage fuel adjustments, that it does not do so until DEC's next fuel proceeding in 2024.
Okay, so you just testified previously that the public staff has not calculated what the percentage increase would be for DEC's large industrial customers without the equal percentage method. Is that correct?
To my knowledge, we have not.
Would you have any reason to disagree with me if I said that without the equal percentage method, that 18% total bill increase would be closer to a 24% total bill increase for DEC's industrial customers?
Subject to check, I'd have to go through those calculations.
And it's true, is it not, that this commission found that rate mitigation for industrial customers was necessary in the sub 929 docket?
Yes, that was part of a settlement. We had two things that helped industrial customers, equal percentage fuel adjustments and a mitigation over a 3-year period. That's part of a settlement.
And would you agree, subject to check, that the percentage bill increase in the sub 929 docket was 18%?
I can't remember the total amount, but have to subject to check. I could say so.
Are you aware that evidence has been entered into the record in this rate case of multiple recent industrial plant closings and related load and jobs lost in DEP service territory?
I was not aware of that.
Does that change your recommendation in this case?
No, I would have to see evidence that equal percentage fuel adjustment elimination would have caused the loss of those industrial customers. I would have to tie it back to equal percentage fuel adjustments.
Are you aware that evidence has been entered into the record in this rate case regarding anticipated price-induced demand erosion in DEP service territory?
I'm not aware of that.
And did you hear the testimony of KUCO witness Helig regarding the affordability concerns of LGS customers?
I heard his testimony, but he did not testify about equal percentage fuel adjustments, to my knowledge.
So do you not recall hearing testimony about affordability being a concern of LGS customers?
Yes, and we're concerned about affordability for all customers, including industrial customers, and we're about residential customers. In a typical month, thousands of families in DEP territory have their electricity disconnected for non-payment. So high electricity prices really affect all customer classes, residential, commercial, and industrial.
Are you aware that the public staff's own evidence entered into the record in this rate case indicates that the U.S. economy is at greater risk of slipping into a recession?
I was not aware of that evidence.
I'm sorry, go ahead.
And I mean, a recession would hurt all customer classes for sure.
Does that change your recommendation?
Not at all.
Are the factors the commission cited to in its sub 929 order approving the sub 929 settlement present now in the current rate case?
No, we were in the midst of the Great Recession back in 2008. We are not in that situation right now.
And you just testified that you weren't aware of the public staff's own evidence regarding economic indicators in the United States at present?
No,
And you state on page 17 of your testimony, let me know when you're there.
I'm there.
You state some of the justifications the public staff relied on in support of the equal percentage method back in 2008, including the large increase in fuel costs and the uncertain economic times. Would you not acknowledge that those factors that justified the public staff's support of the equal percentage method back in 2008 are present right now in today's circumstances?
Can you give me line numbers from that page, please?
18 through 21.
Okay, I see where it is. Can you ask your question, please, again?
So you've testified that the public staff relied on several justifications in support of the new equal percentage allocation, the large increase in fuel costs, the utilities offer to spread the increase over 3 years, and the uncertain economic times. Would you not agree that in today's rate case, these are uncertain economic times?
No, I wouldn't say it's nowhere near like the Great Recession we had at the time. I mean, when we did this rate case in 2008, the Great Recession was well underway. And I'm not an economist. I can't predict or put a quantifier on amount of uncertainty in economic times. Okay, I can't say these conditions are identical to what they were 15 years ago.
Are you aware of the Pactiv Evergreen paper mill announcing its upcoming closure in Q2 2023 in DEP service territory?
I've heard that, but I haven't heard that being tied to equal percentage fuel adjustments.
It's true, is it not, that it was tied to market conditions, which could include the equal percentage method?
Objection, she's asking him to speculate.
I'll sustain the objection.
And turning to page 18 of your testimony, you quote from an affidavit of Tom Lamb. And just for the record, can you identify who Tom Lamb is, please?
He was an engineer in the public staff of what was then the electric division, which became the energy division.
And so you're providing an excerpt from Mr. Lamb's affidavit that he provided in the sub 929 docket, is that right?
Yes.
Okay, and you indicate here on lines 2 through 5, the public staff recognizes the significant and disproportionate impact on the industrial class of recovering these increased costs on a uniform cents per kilowatt hour basis, as well as the need to fairly allocate the rate impact on all customer classes in the period of economic uncertainty, plant closings, and rising unemployment.
I see that, but next couple of sentences, he talks about supporting this methodology of equal percentage adjustments, but they are being modified by spreading the under collection over the billing period of the next 2 billing periods. It was part of the settlement.
If you could turn with me to the sub 929 order.
And which, you remember what tab that was in SIGFRS?
Believe it was potential exhibit number 26.
Okay, I'm there.
If you could turn with me to page 16.
I'm there.
Do you see at the bottom of page 16 and continuing on to page 17, where it says that the traditional methodology, i.e. a uniform cents per kilowatt hour of usage, would result in an approximately 18% increase to the company's large industrial customers?
I see that.
And Do you see further that it says company witness Barkley testified that such a large percentage increase could negatively impact industrial operations and could result in job losses, shifts in production to other states or countries, and plant closings?
I see that, and that's part of why the public staff entered into settlement to spread this large increase right here over a 3-year period.
And did you include an excerpt of Mr. Barkley's testimony that he provided in the sub 929 docket in your own testimony?
I believe I did. If you could tell me the page and line number. Okay, yeah, page 17.
Thank you. Now, since you've included an excerpt from Mr. Barkley's testimony in the sub 929 docket in the testimony that you filed in this rate case, Chair Mitchell, I'd ask that the document pre-marked as Public Staff Potential Redirect Exhibit 139 be identified as Sigford 2, Cross-Examination, Lucas Direct Exhibit 3.
One 139. All right. The document will be marked for identification as requested by council.
Thank you, Chair Mitchell. Would you agree with me that the equal percentage method helps to smooth out annual rate impacts to non-residential customers stemming from volatile fuel prices?
No, because like you said, rate costs are volatile. And we never true up the effect of equal percentage fuel adjustments. If one customer is harmed in 1 year, we never true it up. They never would get their money back with interest. I think equal percentage fuel adjustments create problems. It doesn't really solve them.
It's true, is it not, that without the equal percentage method, you would be exposing industrial customers to more volatility in fuel prices?
They could be exposed to more volatility, yes. But they burn the fuel. They use fuel, and they shouldn't be able to have their costs pushed on to other customer classes just because fuel costs are volatile.
Does that also apply to the residential customers who are being subsidized in base rates?
I'm not testifying about anything about subsidizations and base rates, other than what I've said about equal percentage fuel adjustments.
Because it's a single issue here. Got it. So to your knowledge, has the public staff at any time before now challenged the equal percentage method in any DEP rate case or any DEP annual fuel rider proceeding?
No, it became accepted practice for a while, but now we have House Bill 951 that says we have to work on elimination of cross subsidies. So that's what I've done in my testimony.
To your knowledge, has the public staff at any time before now challenged the equal percentage method in any DEC rate case or any DEC annual fuel rider proceeding?
No.
As we move toward 2030, is it fair to say, since you've already testified that the non-fuel costs are going to be rising as we get closer to 2030, is that correct?
I didn't testify to that.
As your colleague, Mr. McLaughlin, testified to, which you agreed, subject to check this morning, that non-fuel costs recovered through the fuel rider are going to increase as we get closer to 2030.
Yeah, subject to checking of Mr. McLaughlin's statement.
With that in mind, is it fair to say that the fuel rider is actually going to become somewhat of a misnomer and instead we should maybe be calling it the CapEx rider?
No, it's identified in state law 62-133.2 as a fuel and fuel related cost. That's put into state law. So we can't relabel it if it's in state law.
Are you aware that the public staff has stated publicly that it is concerned that public support for the energy transition may start to wane if electric rates increase too much or too quickly?
I'm not aware of that.
Is it the public staff's position that industrial customers who are already subsidizing other rate classes to the tune of $43 million a year in base rates should also bear the brunt of carbon plant implementation costs by paying for a new renewable energy capacity on a per kilowatt hour basis through the fuel rider?
You've put a statement in your question. I can't testify about the $43 billion cross subsidy.
Is it the public staff's position that industrial customers should bear the brunt of carbon plan implementation costs by paying for new renewable energy capacity on a per kilowatt hour basis through the fuel rider?
They have to pay their fair share of costs. They're using energy, they're using kilowatt hours, and all customer classes use kilowatt hours. They should all have to pay their fair share of those costs, even if they're increasing.
Chair Mitchell, if I could have one moment, I think I am done.
You may.
Mr. Lucas, just for clarity of the record, you did testify, did you not, that natural gas prices have increased in recent years?
Hang on a moment, I can give you a very clear answer. Yeah, from 2020 to 2022, natural gas prices did increase greatly. Past few months, they have gone down.
Thank you. No further questions.
All right, we're going to take a morning break now. We will be back on the record at 5 after 11. And just as a reminder, we're going to have lunch at 12 o'clock today. So let's go off the record, please. Please. Mr. Josie, we are at redirect.
Thank you. Good morning, Mr. Lucas, Robert Josie, Public Staff. Mr. Lucas, you and Ms. Crest discussed the equal percentage fuel methodology at length. I'd like to go back to the beginning of the fuel statute to lay a baseline. Mr. Lucas, do you know what year the fuel statute was enacted?
It was 1982.
Okay. And so is it your understanding from 1982 until the settlement in 2008, there was no equal percentage fuel adjustment?
No, rates had to be set on a uniform basis for all customer classes.
Okay. And so for 26 years, the company allocated costs differently than it has since 2008.
That's correct.
And there was a change in the statute in 2007 through Senate Bill 3 that eliminated that uniform increment or decrement requirement. Is that correct?
It was no longer required after 2007.
And that's what allowed the company or its predecessor, Progress Energy, and the settling parties to come to the equal percentage agreement in the settlement of 2008.
That's correct.
And did the elimination of the uniform increment or decrement require any equal percentage increase or decrease?
No,
So it's not a statutory requirement that it be implemented.
it is not a statutory requirement.
Okay, and did any other cost calculation method come out of this change in statute that you know of?
And when the statute came out, it added cost recovery for renewable energy and some other things. And over time, we also added voltage differentiated rates.
Okay. And prior to the adding in of those renewable energy costs, they were recovered through base rates, correct?
Yeah, the company still recovered those costs. It was just in base rates before that.
Okay. And then let's go to what you mentioned, the voltage differential. And the public staff it's not the public staff's position that we get rid of the voltage differential calculation.
No, I recommend that we do keep voltage differentiated fuel rates.
Yeah, and Ms. Kress also stated that when energy prices were high, the utility had a significant under recovery in 2008 of its fuel costs, correct?
Yes.
That,
Objection. I don't recall asking a question or making any statements to that effect.
I can rephrase.
All right, let me see the objection. You may rephrase the question.
In 2008, there was a significant or an under recovery of fuel cost that led to this settlement agreement, correct?
That's correct.
And SIGPR was one of the settling parties in that case.
Yes.
And you had a conversation with Ms. Crest stating that the public staff's position in that settlement was in large part due to the 3-year rate mitigation.
Yeah, that was a large factor.
Mr. Lucas, would you say that the system, how Duke operates its system and buys fuel since 2008 has changed?
Yes, in 2008, Duke Energy Progress was buying a lot more coal and not much natural gas, and that has changed. It buys a lot more natural gas and a lot less coal than it did in 2008.
And are natural gas prices inherently more volatile than coal prices?
Yes.
And again, you stated that HB 951 was enacted and requiring cost causation principles for recovery of cost?
Yes,
And is that one of the main reasons that the public staff's position in this case is to eliminate the equal percentage methodology?
yes.
Mr. Lucas, Mr. Kress asked you some questions about whether or not you knew about any potential or any industrial customers that may seek to leave the state due to the change in the equal percentage methodology.
Yeah, I don't know if any industrial customers said they would leave if they had to pay rates that eliminated equal percentage fuel adjustment.
Okay. Could you please turn to public staff potential redirect exhibit number 150, please? Chair Mitchell, this should be the Duke Energy fourth quarter 2022 earnings review and business update.
All right, let's mark the document, Mr. Josie.
Okay.
Okay, I'm
Like-
there.
I'd like to mark this as public staff redirect examination, Lucas Direct Exhibit 1.
All right, the document will be marked for identification as requested by council.
And Mr. Lucas, could you please turn to slide 31?
I'm there.
Okay, and do you see the graphs on the right side of the slide entitled competitive customer rates?
Yes,
And if you look down at footnote 2, it states that these figures are the typical bill rates and cents per kilowatt hour, correct?
that's correct.
And back up in the graph labeled industrial, DEP NC is at 8.54 cents, correct?
Excuse me, DEP North Carolina's 8.46.
Okay, excuse me. Thank you. And can you read the national average, please?
The national average is 12.21 cents per kilowatt hour.
Okay, so DEP NC is 3.6 or so cents per kilowatt hour, or approximately 1/3 cheaper per kilowatt hour than that.
Yeah, it's rates for industrial customers are about 1/3 less than the national average for industrial customers.
And now, Mr. Lucas, can you turn to public staff potential redirect exhibit 147, please?
I'm there.
And this is a copy of Duke's joint NC low income affordability collaborative quarterly progress report filed in several dockets, including E-2 sub 1219 on August 12th, 2022, correct?
That's correct.
Chair Mitchell, I'd like to mark this as public staff redirect examination, Lucas Direct Exhibit number 2.
All right, the document will be marked as marked for identification as requested by council.
And Chair Mitchell, I would object to this line of questioning because I did not ask this witness any questions about the proposed customer assistance program or the low-income affordability collaborative.
All right, I'm going to overrule the objection because I haven't heard the questions yet. Let's let Mr. Josie ask his questions and then you may object if necessary at the right time.
Can you turn to page 81 of 548 in that exhibit?
I'm there.
And do you see the row in this chart labeled proposal number 24?
Objection, Chair Mitchell. This redirect is not responsive to anything that this witness was asked on cross.
Ms. Kress asked many questions on cross-subsidization outside of the fuel allocation.
Chair Mitchell, that was in base rates without any specificity of where specifically those cross subsidies were coming from. And the Cross subsidy number that I referenced actually was from Direct Exhibit 4, which did not include the subsidy total resulting from the proposed customer assistance program.
This program will go into base rates to be recovered.
When you say this program, Mr. Josie, be specific.
The customer assistance program.
And Chair Mitchell, I'd just remind the commission that Mr. Lucas testified repeatedly in response to cross-examination questions that he is not testifying about base rates or cross subsidies and base rates and could not answer questions to that effect.
And those times those questions were objected to, they were overruled, if I recall.
All right, Mr. Josie, Ms. Kress, I'm gonna allow, Mr. Josie to ask his question. So far, he's only asked, about what's in, the reference to proposal number 24. Let's ask the question. And then if we need to go through this again, we can, Ms. Kress. Your objection, that
Could you
is.
turn to page 82, the next page?
I'm there.
Could you just read Sigford's comments on that page?
Objection, Chair Mitchell. This is not relevant to anything this witness testified to on cross-examination and falls clearly outside the scope of what was asked on cross. Specifically, the interclass cross subsidy figure that I asked Mr. Lucas about did not include the subsidy for the customer assistance program.
I think she was speaking generally in many questions prior to the specific question she's asking, or she's talking about right now. And this, all I'm asking Mr. Lucas to do is read this into the record.
All right, I'm gonna overrule the objection for now.
Okay. Mr. Lucas, could you please read Sigford's comments on that page?
Yeah, this is Sigford's comments on one of the low-income proposals. And Sigford says it violates cost causation principles to recover class from all classes of customers. Costs should be contained to residential class of customers. This proposed interclass cross-subsidization is not consistent with existing North Carolina law, in particular H 951.
And Mr. Lucas, Ms. Kress asked you some questions about, about the cross subsidization. And you are not, again, as you said, the public staff's cost of service witness, but are you generally aware that some plant costs are built to serve all customers and thus they must be allocated to customer classes?
That's correct.
And fuel is not allocated in the same way that production plant is allocated, is it?
That's correct.
If a customer, any customer, consumes a kilowatt hour of electricity, there is a direct link between the amount of fuel costs the utility experiences in there.
Yes.
And if a customer doesn't
Mr. Josie, I did not hear the end of your question before Mr. Lucas answered yes. So would you restate your question just so it's clear in the record and I understand what you asked, and then you can respond again, Mr. Lucas, if you would.
If a customer, any customer, consumes a kilowatt hour of electricity, there is a direct link between the amount of fuel cost the utility experiences, correct?
Yes.
And if a customer doesn't consume any electricity in a given month, there may be some fixed charges that they incur, but they don't pay for any fuel, do they?
That would be correct.
And that's because they didn't cause any fuel to be burned, isn't it?
That's correct.
Ms. Kress asked you about transmission costs for delivery of purchased power being recovered through the fuel statute. Do you remember that?
Yes.
Transmission is a real cost that is necessary in order to deliver purchased power to the utility system. Is that correct?
That's correct.
And in some sense, those costs are similar to transportation costs necessary to deliver coal or natural gas or uranium to the utilities power plants.
And transmission transports electricity.
Ms. Kress also asked you about the symmetry based on whether fuel costs go up or down Do you remember that?
Yes,
And do you believe rates should be set on a, well, everything works out in the end, or based on costs being recovered in a manner that they will be incurred or are incurred or caused?
yes, they should be based that way,
They should be based on who incurs those.
on
costs.
who causes those costs.
Yes. And Ms. Kress asked you about single issue rate making. Fuel adjustment is by definition, single issue rate making, is it not?
That's right. General Statute 62-133.2 calls out fuel and fuel-related costs as a separate rate-making process.
And fuel is not really allocated, is it? Or at least it wasn't in 2008, correct?
I'm sorry, say that again?
Fuel is not really allocated, or at least it wasn't in 2008, correct? More of a methodology.
Well, we had that general statute in 2008.
Okay, let me ask it a different way. Is fuel a cost that is directly attributable to the use of electricity?
Yes,
And it isn't in your testimony that 951 requires it to be recovered as its cost, isn't it? Or is it?
it did. 951 didn't eliminate cross subsidies, so we have to base it on costs.
And do you recall Ms. Bowman testifying in this case?
Yes,
And do you recall her stating that what she said was a potential mitigation factor for industrial customers?
Objection. This is outside the scope of anything that this witness was asked on cross. I did not reference any of Ms. Bowman's testimony in any question for this witness.
She did ask several questions on cost mitigation.
Chair Mitchell, I think this is outside the scope of the questions that this witness was asked on cross.
All right, Mr. Josie, ask your question. And I'm gonna overrule the objection for now, ask your question, and we'll go from there.
I'm sorry, can you say that again, please?
Yes. Ms. Bowman stated that there were several rate mitigation efforts Duke had proposed that will help industrial customers. Do you recall that?
Yes,
And was one of those the equal percentage fuel methodology?
I don't remember that part.
No further question.
All right, take questions from commissioners at this point. Any questions from commissioners? Commissioner Clodfelter.
Mr. Lucas, just so that I am crystal clear, please walk me through the steps employed in application of the equal percentage methodology for assigning fuel costs.
Yeah, I can go to that.
I
The
just
way-
need the steps.
Okay, I can do that. What happens to set fuel rates on an equal percentage basis, Duke Energy takes total fuel costs without consideration of customer class or anything, say, for example, $300 million. And it looks back at revenues from the previous year. And if 40% of those revenues were from residential customers, they get 40% of that $300 million. In other words, $120 million of fuel cost is assigned to the residential customers without any consideration of kilowatt hours or cost they triggered. So Duke says, okay, residential customers, you causing an increase of $120 million. Then Duke goes back and looks at, okay, how many kilowatt hours is that going to be in the prospective period? So they they would take that $120 million and divide it amongst all the kilowatt hours and set rates for residential customers. Then it'll go back to another customer class, say lighting. Takes that $300 million fuel, say under recovery, say lighting, you were 5% of revenues, so you're gonna pay 5% of that $300 million. It's not based on actual usage, it's just based on, for lighting customers, it'd be 5% of the revenues from the previous year. So they would be assigned 5% of that $300 million. That'd be $15 million. And they say, okay, lighting, you used X kilowatt hours. We're taking $15 million cost increase and allocate it over your kilowatt hours. That's not a fair way for fuels. We established that back at the generator, any customers that trigger kilowatt hour generation, they have to pay their fair costs. The generator makes kilowatt hours to serve all customers. It doesn't make kilowatt hours for certain customers at certain times.
Thank you, sir. That's all I have.
Mr. Lucas, you've touched on this a bit in your testimony this morning, but I just want to make sure I'm clear, or at least try to be clear. Can you talk about the timing of a decision on this issue, a decision by the commission? Help me understand how the commission's decision on this issue would be implemented as it relates to rates that are ultimately charged to customers.
Okay, well, we anticipate a commission decision long before December 1st of this year. That's when DEP's fuel rates will have to take effect, the ones that it applies for this coming June. Public staff wants to take the commission's decision, and if the commission agrees with the public staff, eliminate equal percentage fuel adjustments in DEP's fuel case that will be filed in June.
Got it. Thank you. All right. Questions on commissioners' questions? All right. Mr. Lucas, thank you for your testimony and for your work on this case. You may step down and also be excused, sir. And Mr. Jesse, I'll take motions from you and then I'll take motions from council on the cross exhibits.
Public staff moves to have witness Lucas's 7 exhibits moved into the record.
In SIG 2 would renew its objection and motion to strike with respect to Lucas Exhibit 6.
All right. I've ruled on that motion and objection, and I will allow Mr. Josie's motion to move into the record the exhibits to the Lucas testimony.
The public staff would also move that public staff redirect examination Lucas direct exhibits 1 and 2 be entered into the record.
All right, that motion is allowed.
And SIG 2 would move that it's SIG 2 cross-examination Lucas direct exhibits 1 through 3 be entered into the record.
That motion is allowed.
Thank you.
Public staff calls David Williamson. Stand.
All right, Mr. Williamson, you are still under oath, just reminding you. may proceed.
Tom Felling with the public staff. Mr. Williamson, would you please state your name, business address, and current position for the record, please?
My name is David Williamson, and I'm an engineer with the Public Staff's Energy Division, and my address is 430 North Salisbury Street, Raleigh, North Carolina.
On March 27, 2023, did you prepare and cause to be pre-filed in this docket direct testimony consisting of 51 pages and one appendix?
Yes, I did.
Did you have any changes or corrections to your pre-filed direct testimony?
Yes, I did.
Did you file those corrections in docket E-2 sub 1300A on May 4 and May 10, 2023?
Yes, I did.
Do you have any additional corrections to that testimony to note?
No, I do not.
Other than those corrections, if you were asked the same questions today while on the witness stand, would your answers today be the same?
Yes, they would.
On May 1st, 2023, did you prepare and cause to be pre-filed in this docket supplemental testimony consisting of 9 pages and 2 exhibits?
Yes, I did.
Did you amend this pre-filed supplemental testimony on May 4th, 2023 in this docket to include line numbers?
Yes, I did.
Did you have any changes or corrections to your pre-filed supplemental testimony?
I did. Yes.
Did you file those corrections in docket E2 sub 1300A on May 4 and May 10, 2023?
Yes, I did.
Do you have any additional corrections to that supplemental testimony to note?
No.
Other than those corrections, if you were asked the same questions today while on the witness stand, would your answers today be the same?
Yes, they would.
On May 5th, 2023, did you prepare and cause to be pre-filed in this docket settlement testimony in support of the partial settlement between DEP, DEC, Sierra Club, NCJC et al., and the public staff regarding affordability issues consisting of 4 pages?
Yes, I did.
Do you have any changes or corrections to your pre-filed settlement testimony?
No, I do not.
If you were asked the same questions today while on the witness stand, would your answers be the same?
Yes, they would.
And on May 4th, 2023, did you prepare and cause to be pre-filed a summary of your testimony in the E2 sub 1300A docket?
Yes, I did.
Do you have any changes or corrections to the summary of your testimony?
No, I don't.
If you were asked the same questions today while on the witness stand, would your answers be the same?
Yes, they would.
Chair Mitchell, at this time, I would move that the pre-filed direct and supplemental testimony as corrected, settlement testimony, and summary of testimony of public staff witness David Williamson be entered into the record as if given orally from the stand, and that public staff Williamson D supplemental testimony exhibits 1 and 2 be marked for identification as pre-filed.
All right. The direct testimony for public staff witness Williamson filed in this docket on March 27th, 2023, consisting of 51 pages, will be copied into the record as if given orally from the stand.
Mitchell,
As
I'm sorry to interrupt, Chair Mitchell. I believe that there were also corrections that were filed with respect to Mr. Williamson's direct testimony.
I'm about to get to
I'm
that.
sorry.
That's fine. All right. Why don't we strike my response to council's motion, and I'll start over. The direct testimony of public staff witness Williamson filed in this docket on March 27th, 2023, consisting of 51 pages, as corrected on May 1st and later on, on May 4th and later on May 10th, will be copied into the record as if given orally from the stand. The supplemental testimony of public staff witness David Williamson, filed in this docket on May 1st, 2023, consisting of 9 pages, is later corrected on May 4th and May 10th, will be copied into the record as if given orally from the stand. The 2 exhibits to that supplemental testimony will be marked for identification as they were when pre-filed. Settlement testimony of public staff witness David Williamson, filed in this docket on May 5th, 2023, consisting of 4 pages, will be copied into the record as if given orally from the stand. And the summary of the witness David Williamson's testimony will be copied into the record, filed in this, or provided in this docket on May 4th, will be copied in the record as if given orally from the stand.
Thank
All
you,
right.
Chair Mitchell. Mr. Williamson is now available for cross-examination.
All right, Sigfrid, you're up.
Thank you, Chair Mitchell. Mr. Williamson, would you agree, subject to check, that the North Carolina League of Municipalities, or what I'll refer to in this line of questions,
Ms. Kress, if you would get the mic in front of you. There you go.
Would you agree, subject to check, that the North Carolina League of Municipalities, or what I'll refer to in this line of questioning as the League, intervened in DEP's last general rate case in docket number E2 sub 1219?
Subject to check.
And so is it fair to say that the league had notice of both the comprehensive rate design study and the cost of service stakeholder group that the commission ordered the parties to undertake after the sub 1219 rate case?
I'm not entirely sure how notice to the rate design study roadmap, as it was titled, was given out. That it was. I don't recall if it was in the commission's order or if it was amongst the parties themselves.
Okay. Can you turn with me to what's been previously entered into the record as Sigford 2 cross-examination, Reed, Byrd, direct, and rebuttal Exhibit 1, which was pre-marked as Sigford 2 potential Exhibit 76, if you would turn in the binder in front of you?
You said 76?
Yes, sir.
All right. I'm there.
Okay. And can you turn to page 53 of that exhibit, please? And that page lists the stakeholders who participated in the comprehensive rate design study. Is that correct?
That appears to be what it is, correct. And then it also shows their participation in respective working groups.
Do you see the league listed on that list of stakeholders who participated in the comprehensive rate design study?
Uh, Not specifically the league. I don't know if they,
Do you see the North Carolina League of Municipalities listed?
no, I do not.
And if the league had wanted to participate, they would have been able to. Is that right?
Again, I'm not sure of how notice of this collaboration was involved, happened. But I assume that through the number of parties that were involved, that if they wanted to, they could have participated, yes.
Okay. And if you could turn with me to what's been previously marked as Sigford 2 cross-examination, Metz and McLaughlin direct and settlement Exhibit 1, which was pre-marked as Sigford 2 potential Exhibit 88. If you could please
I'm
turn,
there.
please turn to page 88 of that exhibit. Is this the list of stakeholders who participated in the cost of service stakeholder process that followed the sub 1219 rate case?
It is.
Do you see the NC League of Municipalities listed anywhere on that stakeholder participant list?
I do not.
Okay. All right. If you could now turn with me to Sigford 2 potential cross exhibit 78.
Okay.
If you could turn to page 20 of this document, which I will ask Chair Mitchell if it could be identified as Sigford 2 cross-examination D. Williamson direct supplemental and settlement exhibit number 1.
All right, just confirm for me the document that we're looking at.
Exhibit 78 of Sigford 2's.
And what is that document?
It's the NRRI
Okay.
by Ken Costello.
Okay. All right, the document will be marked for identification, as requested by council.
Can you turn to page 20 for me?
I'm there.
Okay. Do you see on that page where it says some of the elements of social welfare may be conflicting? For example, discounted rates to low-income households may diminish economic efficiency and fairness from the perspective of the general ratepayers.
Is this under section D?
It is. It's the first sentence. Do you see where it says that phrase that I just read into the record?
Just 1 second. Okay.
Do you agree with this statement?
Not entirely. I guess what I have to say is that this kind of, or I guess to preface it, this document is 80-some pages long and written by Ken Costello, who I know to be an economist of sorts, and so he's kind of talking more broadly in most of his productions, but so I don't know what part of I guess utility service he may be referring to in this piece, but with regard to how discount rates impact the efficiency of things, I would say that it's really unsure how a discounted rate would influence or impact a customer, specifically a low-income customer. It's really just it's unsure how they would react to the discount as far as diminishing the economic efficiency as it's been written here.
So just to be clear, do you mean you are unsure how it would impact a low-income customer and their usage?
Well, I think that it would be based off of how every individual low-income household is responding to particular discounts. Most of the time, for low-income customers or low-income households, I believe they would view a credit as an ability to spend those funds on other items that they need at the time, as opposed to spending it on potential utility services.
Okay, do you see in footnote 57, about halfway down that paragraph, where it says economic efficiency helps to avoid the waste of resources from both consumption and production?
I do see that. And I guess to respond to that, as far as like low income customers who are struggling to pay their bills on a monthly basis, I wouldn't see them as a customer that would increase usage per se, just because they receive a credit. I believe they're constantly aware of the bills in all aspects of the types of bills that they have to pay, and so keeping all bills from their perspective minimized is in their best interest.
And what are you basing that belief on?
I'm sorry?
You just testified to your belief, and I'm asking what you are basing that belief on.
It's just me it's my understanding of how all low-income customers really have different perspectives of where they are as far as their energy burden, or how they use their energy, or what other type of life experiences they may be involved with at the moment.
Okay, could you please turn to page 30 of the same document?
I'm here.
Do you see there under section 2, the very first sentence reads, discriminatory pricing occurs when price differences for the same service do not correspond to cost differences?
I see that.
Do you agree with that statement?
So So my understanding is that all classes are going to have different levels of service not different levels of service, but different customers that cause their own individual costs on the grid. But that's why customer classes are created in order to combine all of these like customers. And within that, there's going to be some ebb and flow as far as I guess good users of the grid and not so good users of the grid.
So is your answer that yes, you agree with that statement, or no, you do not agree with that statement?
I don't believe that there are discriminatory prices based off of the prices that the commission approves.
So is it your testimony that the customer assistance program as proposed is not discriminatory pricing?
So I believe the commission has the full authority to approve any type of assistance program. It's done it in the past with regards to economic development riders and job retention riders, and a means to provide a level of assistance to a particular class of customers. So I believe the commission has the ability through recently approved tariffs to apply a similar type of conclusion to this customer assistance program.
And I understand that to be your position, but my question is, does the customer assistance program as proposed include discriminatory pricing?
I don't believe it includes discriminatory pricing.
Okay, if you could turn with me to page 63.
You said page 63?
Yes. Do you see under section C where it says regulators should consider the compromising effects that advancing affordability has on economic efficiency and discriminatory free rates? To what extent do regulators want to diminish economic efficiency or require general ratepayers to subsidize a group of low-income households? How much discriminatory pricing will they tolerate? Do you see that?
I do see that, yes.
And so, understanding your testimony here this morning, I take it you would disagree with this statement?
So I guess there's two things. One, again, I'm not entirely sure what the perspective of this entire document from this one author is trying to generate. There could be multiple publications from different authors that could come up with different conclusions or statements. But I guess, but on a second part, because I mean, I do want to answer your question. What could you repeat the question?
The question was, I take it that you disagree with this statement.
This is on page 63 to 64. I guess, what's the starting point again?
Regulators should consider the compromising effects that advancing affordability has on economic efficiency and discriminatory free rates.
Yes. And I believe the commission does recognize that they do have the ability to set what is an allowable amount of cross subsidy that fits the public policy.
Okay, if you could turn with me to page 64, footnote 162. Do you see the first sentence there reads, if these households face below cost rates, they would tend to consume more energy?
I see this statement, and I guess I would say that it's unclear how individual customers would change their consumption habits from a credit.
And by credit, do you mean a bill credit in the form of a discount customer assistance program?
Correct. As far as if they face below cost rates, they would tend to consume more energy. I don't know, or I don't believe that customers I- customers as a whole, I believe is what this kind of statement is referring to, but it's unclear how individual customers would respond.
So do you agree or disagree with this statement?
I disagree.
And what is that disagreement based on?
So I guess again, it's me saying that it's unclear how individual customers would respond to it. It's to make a generalized statement when individual customers and individual rates on these customers that they're experiencing, along with all the other hardships that they have, us making a statement that they would use more energy when they're already struggling to pay a bill that's currently available, they would, I don't believe they would increase their energy. I believe they would remain constant, if anything.
So is it your testimony that low-income customers do not respond to price signals?
I believe that all customers respond to price signals. But I
And-
believe that all customers are going to continue to use relatively where they are. I don't think that customers would use more, particularly low-income customers would use more considering all of the other challenges that they have to experience and work with.
Could you please turn with me to SIGFR 2 potential cross exhibit number 79? And this is a regulatory review from the University of Pennsylvania article by Ken Costello that Chair Mitchell, I'd request be marked as SIGFR 2 cross-examination D. Williamson direct settlement and supplemental exhibit number 2.
All right, the document will be marked as requested by council.
Thank you. Do you see on page 2, Mr. Williamson, the third full paragraph of this article states, political pressures and legislative mandates have ultimately compelled utilities, with approval by their regulators, to protect low-income households from unaffordable utility bills. Some observers view these actions as taxation by regulation that requires slightly higher rates to the majority of customers to pay for special utility assistance initiatives. Some observers view these actions as taxation by regulation that require higher rates to the majority of customers to pay for a SUA or special utility assistance benefiting a smaller target group of customers. Do you see that statement?
I do.
Do you agree with that statement?
So, I mean, in essence, it's causing other customers to pay for particular items of another customer's benefit. And I guess the response I have to that is kind of similar to the response that I gave just a moment ago about how the commission is already ruled on and ordered in previous rate cases and deemed it reasonable and appropriate to associate causing other customers to pay for a benefit to particular customers. And so I believe that it is within the commission's ability to apply that discretion when it is appropriate. And I believe it depends on the level of appropriate that we're talking about. And so to the cap, I mean, that's essentially why we've agreed to a pilot. And so through the settlement discussions, we've agreed to it as a pilot. And that's really to assess, or in my view, it's an ability for us to review over the 3-year period to assess the benefits of this proposal and how that would influence customers or impact customers, and as far as disconnections or reduced rearages. So there is a potential benefit there. And so it's just trying to better understand that benefit and how we might modify this program in the future going forward that still keeps us within this realm of reasonable and appropriate as far as public policy, because the commission kind of took this step in the last rate case with regards to initiating this low income and affordability collaborative to make a deeper dive on affordability issues and how we're going to address them and how we're going to attempt to deal with them. And I think the LIAC produced a well thought out and surely a very thorough report with an immense amount of data and data points and discussions with a number, and when I say a number, I mean nearly 24 different intervening bodies meeting regularly and trying to figure out this challenge of affordability and what is within the realm of reasonable and appropriate that the commission can approve and assign this particular program to be a benefit to these particular low-income customers.
Mr. Williamson, did House Bill 951's enactment into law come after the commission's order in the sub 1219 rate case?
This is the first rate case where HB 951 is applicable, yes.
And you acknowledge, do you not, that the customer assistance program as proposed is by definition an interclass subsidy?
It is. However, there are a lot of cross subsidies around that the commission has given its approval on in the past, like I was saying, with the economic development riders that are to the benefit of increasing load to non-residential customers. In addition, the job retention or load retention rider that was approved, I believe it was in the 1146, 1142 general rate cases for Progress and Duke Carolinas, where it was intended to incentivize the the particular non-residential customers to remain in North Carolina.
And just to be clear, all of those programs that you just listed as examples predate the enactment into law of House Bill 951, correct?
That's true, but the commission still remains its ability to approve and apply what it deems to be within the realm of reasonable and appropriate in every rate case proceeding.
If you could please turn with me to SIGFOR 2 potential cross exhibit number 28.
All right, we will pause there. Take our lunch break. We'll be back on the record at 1 o'clock. Let's go off the record, please. All right, Ms. Kress, you may continue.
Thank you, Chair Mitchell. Mr. Williamson, would you agree, subject to check, that the low-income stipulation filed in this docket on May 4th, 2023 includes a sentence that reads, "The stipulating parties acknowledge and agree that the commission must determine whether the company's proposed cap is consistent with existing law and the public interest"?
Subject to check.
You would agree, subject to check?
Yes.
Thank you. Now, if I could have you turn to Sigford 2 potential cross exhibit number 28.
I'm at exhibit 20 or potential exhibit 28.
And at this time, Chair Mitchell, Sigford 2 would ask that Sigford 2 potential cross exhibit 28 be identified for the record as Sigford 2 cross examination D. Williamson direct settlement and supplemental exhibit number 3.
Document will be marked for identification as requested by council.
Thank you. Mr. Williamson, do you see in this email chain the very first paragraph that says, "Dear counselors serving on the LIAC Subteam C, I asked Lucy Edmondson of the NCUC public staff to respectfully share her knowledge about applicable North Carolina constitutional, statutory, case law, or public policy directives on the subject of cross subsidies and our work on LIAC. Lucy replied with a cogent and succinct primer on the subject and was gracious enough to grant permission to share it with the LIAC team members. See the string below for Lucy's primer."
That's what it reads.
Okay, can you turn the page with me, please? And do you see 4 arrows down the sentence that says, "By using cost causation principles to develop rates, people's bills are based on their usage, and they have an incentive to conserve to lower their bills. When rates are not based on cost causation, but perhaps on income, the tie between usage and the electric bill can be severed, and the incentive to conserve can be reduced or removed."
That's what it says.
And would you agree with this statement contained in the primer on cross subsidies that was shared with LIAC Subteam C by Chief Counsel for the Public Staff?
So it's a quite lengthy email from Miss Edmondson. I haven't read the entire email. I wasn't privy to this email as my name was not added to the distribution list of it. So this is new to me. But I will say that just kind of getting an idea of the email itself. I don't want to take one sentence out of the email out of context for what might be explained later on.
So you don't disagree with the statement from?
I'm trying to get an understanding of the sentence itself with regards to the entire email.
So is it your testimony that you can't answer unless you were to read the entire email?
Um, so I guess if you could just kind of restate the question.
Sure. The question is, Do you agree with the statement that I just read?
Um, again, not necessarily have read the entire document. It kind of there. I'm reading it as the potential for income-based rates, and we don't have income-based rates in North Carolina.
Understood. Thank you for that. Did you hear your colleague, witness Lucas, testify this morning?
I did.
Do you agree with witness Lucas that House Bill 951 requires that interclass subsidies be eliminated?
I don't believe that's what the statute says. I believe the statute explicitly says minimize to the greatest extent possible. So I don't agree with your characterization of HB 951.
So just to be clear, you're saying you don't agree with witness Lucas's testimony?
I don't remember that exact line from him, but I do know that the statute is explicitly clear when it says minimized to the greatest extent possible, when it talks about cross-subsidization.
So if the transcript were to show that witness Lucas said that interclass subsidies should be eliminated, your testimony here today would be that you would disagree with witness Lucas on that point?
Objection. Chair Mitchell, this question has been asked and answered. He's been asked if he agreed with Mr. Lucas's testimony, and he's already given his answer to that question.
Chair Mitchell, respectfully, he did not answer that exact question, and that is why I'm asking a slightly rephrased version of it.
All right, I'm going to overrule the objection, answer this question, and then let's move on.
Sure. So my understanding of the statute is that it's to minimize to the greatest extent possible any cross-subsidization.
Chair Mitchell, could you please instruct the witness to answer the question that was asked?
Let's do this. Ask the question again, and then answer the question she asks.
Thank you. If the transcript were to show that witness Lucas testified this morning that House Bill 951 requires interclass subsidies to be eliminated, would you disagree with witness Lucas?
If that's what's in the transcript, I would say that I disagree with Mr. Lucas.
Thank you. Would you contend that a 0.5 percentage point rate increase constitutes rate shock?
0.5%?
That's correct.
I would say that it depends on what that 0.5% is being applied to. If it's $1, I don't know what 1/2 so I guess 1/2 cent. I don't believe that would be considered rate shock per se. It depends on the volume of dollars that are being associated.
If you could please turn with me to your testimony now. And it's true, is it not, that you filed for the first time in this docket your recommended class rates of return on May 1st, 2023?
Is this my direct or my supplemental?
I'm asking you.
Well, I filed 2 different times, so multiple times actually.
Would you agree, subject to check, that you filed your recommended class rates of return for the first time in this docket on May 1st, 2023?
I would say that it was amended, I believe, on May 10th to be perceived as illustrative examples of rate of returns.
Did you file for the first time in this docket your illustrative rates of return on May 1st, 2023?
Subject to check. Like I said, I've filed multiple times on, I believe, the 1st, the 4th, and the 10th.
And that would have been after the discovery deadline had already passed in this rate case, correct?
I believe so.
And you testified that you amended that testimony twice since May 1st, is that correct?
That's correct. I believe once was for Uh, I believe once was for adding numbers. It was more of an administrative type change, and another was for corrections. I believe that's correct.
And as recently as this past Friday, May 12th, you amended your testimony?
May 12th.
Chair Mitchell, can council please direct the witness to what document she's referring to?
The testimony that was filed on behalf of Mr. Williamson on Friday, May 12th.
Chair Mitchell, if I may, for the record, that was we were filing pages that were reflective of the corrections that had previously been made to the testimony. Those corrections were not new corrections as of Friday, May 12th. Those were pages that could be inserted into the record. I think all the testimony from Mr. Williamson that's relevant to this panel has already been identified at the beginning of offering him as a witness.
All right, Ms. Kress, let's direct the witness to the testimony you want him to review.
Sure. Mr. Williamson, can you please turn to your supplemental exhibit number 1?
Is this I assume this is the corrected exhibit that was filed at some point in time?
So you're the witness. If you
Yes.
could turn to your supplemental exhibit number 1.
I'm going to go to my corrected supplemental exhibit number 1. And I'm there.
Are you aware of whether any other party has been able to verify or replicate the results of your class rate of returns that you have here in your supplemental testimony exhibit number 1?
I have not been approached by any other party or my legal staff by any other party addressing whether or not they've had concerns with determining the rate of returns.
Okay. And now your supplemental exhibit number 2, if you could turn there, please. Do you provide 3 different versions of class rates of return for each rate year in exhibit number 2?
So exhibit number 2 is a variety of illustrations that kind of give the commission an idea about depending on their recommendation for the final revenue requirement and how that should be distributed, what that would look like as far as a rate of return and a % increase for the individual customer classes. And so there's 4 different examples here. There is the class revenue changes equal to the NC retail change. There is the base case with no revenue change. There is an equal rates of return for all classes. And then the fourth one, while it says public staff recommended revenue distribution, it should be public staff's illustration of revenue distribution. I believe that might have been overlooked in the corrections.
And so just to be clear, does that mean the public staff is not actually recommending its illustrative class rates of return?
So when I was putting these exhibits together, I believe Mr. Metz touched on it a little bit during when him and Mr. Witness McLaughlin were up here. But I guess what I'm getting at is that there was a whole process involved with how I get to my exhibits. And he talked about how there was discovery that took place where in an ideal world, it would take 2 weeks. Sometimes it took longer than 2 weeks. And then there might be multiple iterations of discovery that would need to be had on particular items. And so eventually, a pencils down moment has to occur so that the public staff can feed its recommendations and proposals on individual items that various public staff witnesses took a deep dive into, tried to investigate its reasonableness, and put forth a good recommendation for the commission's consideration. And so all of that being said, each individual recommendation on various topics will then get fed and provided to the accounting witnesses, who would then take their numerous spreadsheets of different recommendations and kind of roll it all up together in order to figure out what a total revenue requirement would be for not just one revenue requirement, but for the base case, rate year 1, rate year 2, and rate year 3, as far as what revenue requirement would we be working with under the public staff, which I think at this point we're at partially settled, partially public staff position as far as what the public staff accounting witnesses have provided. And that information, when they come up with their final revenue requirements, are what is provided to me in order for me to run those revenue requirements through the various spreadsheets that I have in order to come up with these exhibits. And so that being said, I know it's a long-winded, but it's a long process and it takes a lot of time. Whenever I was provided the revenue requirement, because like I said, there has to be a pencil down moment. Whenever I was provided the revenue requirement, there was very little time to move from a final revenue requirement to these spreadsheets. However, in that little bit of time, I was able to get the core principles that the public staff highlighted in its testimony, as far as where we would see these, or where these returns and where the revenue requirement distribution would look like under the modified average and excess cost of service methodology and the public staff's longtime advocated rate apportionment principles. And so, like I said in my testimony, we had some challenges in distributing these revenues in order to adhere to all of the public staff's principles, but we placed a greater focus on the second rate principle, which was to keep rate of returns within a band of reasonableness. And so it's at 10% of the NC Retail's rate of return. And so what you see here as this public staff recommended revenue distribution, how it's titled, it's more applicable to be an illustration of what it would take under the modified average and excess, and keeping the class rate of returns within a banded window. And this is the result of what that would take in order for that to happen. And the company, my observations from Read Exhibit 10, it's a great exhibit. They give a historical picture of, I believe it's 4 class rate of returns, and it's a historical look. And so I think it's over the last 10 or 12 years, it kind of illustrates where the rate of returns have fallen. But if you look, there's a dotted line on the graph that's plus or minus 10% of the rate of return. And so I believe that is the target that even the company is aiming for whenever it's assigning rate of return.
So just to unpack, that was a very long answer. So just to unpack that answer a little bit, you testified that you gave greater emphasis, I believe were your words, on the public staff's second rate apportionment principle. What is the public staff's first rate apportionment principle?
So the first rate apportionment principle is that no individual class would experience an increase greater than 2 percentage points higher than the NC Retail increase.
And are there any other rate apportionment principles that the public staff considered?
There are. If I could switch over to it. So the So you've heard the first rate principle and you've heard the second rate principle. The third rate principle is that all class rate of returns move closer to parity with the overall NC retail rate of return. And the fourth rate apportionment principle is that subsidization among the customer classes is minimized.
And so you said that the public staff gave greater weight to the second principle than it did to the others. Is that correct?
With regard to in taking into consideration all of the rate principles, we applied greater focus on the second rate principle as opposed to the first rate principle, because the first rate principle had its challenges that were unattainable.
So if you had to rank the principles in the order in which the public staff emphasized them in its rate of return recommendations, how would you rank those from greatest emphasis to least?
I don't know if I would rank them per se. I believe that all of the rate principles are valid in their own regard when determining whether or not a revenue apportionment is reasonable and appropriate.
So you said that you gave greater emphasis to the second principle with relation to the first. What about with relation to the fourth principle?
So subsidization among the customer classes is minimized. So under the public staff's, I'm going to say illustrative, even though it says recommended, under that, I believe, so I guess if we go back to it, you can pick any of the rate years. I'm just going to go with the rate year 3 as an example, just because it's right in front of me. If you look at Williamson D. Supplemental Testimony Exhibit 2.3, page 404, and then you look at line 11. That is showing a rate of return that all classes are within that band of reasonableness for that plus or minus 10% on the rate of returns. And so the public staff views any rate of return for a customer class whenever it's dealing with revenue changes or rate increases or decreases into particular classes. With a rate of return that's within that band of reasonableness, we don't see any cross subsidization. And I kind of have to go back to that Read Exhibit 10, where every year it's going to be a different rate of return that's realized. It's all dependent on the number of customers, how the usage, that's the energy that's used, the demand that's accumulated for each class. All of that is going to be different from year to year. And so the cost of service is just a snapshot in time. In this case, we're looking at the test year of 2021. And so under the test year of 2021, this exhibit 2.3, in order to satisfy that rate of return band of reasonableness, this is the work that would need to get done. I don't know if I've answered your question or not.
So wouldn't you agree with me that your Exhibit 2.0, page 3, reflects class revenue changes equal to the North Carolina retail change?
Which one? 2.0, page, which of 4?
Page 3.
Class revenue changes equal to the NC retail change.
So your answer is yes?
I don't know what your question is. I'm sorry.
You would
Is that what this says?
correct
Yes, that's what it says.
Okay.
For rate year 0.
for rate year 0.
the
And
base
you
case.
provided, I'm sorry, what did,
So for the base case, that's what rate year 0 means in this case, is the base case.
and so you provided this document for each of the 3 rate years, correct?
So there are 3 rate years in which the commission will need to set rates for, but there are 4 individual components. The first rate year is a combination of the actual investments in the base case that were completed and put into plant into service, And then there are an incremental projected amount of projects that are in the multi-year piece. And those two combined will total up to the rate year one revenue requirement that will be the rates actually charged to customers. There's not a revenue requirement for the base case unless the commission doesn't approve the multi-year case. That's essentially why I added in an individual case, was to give the commission an idea of what it would look like if the multi-year was not approved.
Okay, and so you said that your recommended rates of return for all classes changed from being a recommendation to just an illustrative example sometime between when you initially filed them on May 1st and the date upon which you amended your testimony. Can you explain what changed and why?
So like I was saying before, I was kind of crunched on a deadline. I was given the number the day of the filing. And so I had spent the entire day focusing on just this one piece of testimony and exhibits. And so what is here is, like I was saying, is that while I did have the ability to provide the rate principles that the public staff advocates for to the greatest extent possible that we could, placing the focuses where we did, this is the product of what it would take to make that cost of service application and the public staff's rate apportionment principles with the focus on the second rate principle happen. And so, yes.
And just for the record, the public staff is recommending in this rate case to reduce the interclass subsidy by 10%. Is that correct?
With regard to witness Reed's proposed change, is that what you're referring to?
That's correct.
Okay. So my understanding is that 10% change from witness Reed is just, it is a method that they are placing in this case. It's a method they're placing in this case in order to provide some gradualism, from the change in cost of service to try and alleviate some of the increases because of the change in cost of service. And I believe, because I wasn't here during when witness Reed and Byrd were on the stand, I believe that witness Reed stated that this was as a result of the change in cost of service. And so she believed that it was only going to be applied to this case in this time.
And is it your understanding that 10% subsidy reduction remains flat over the 3-year multi-year rate plan period? In other words, it doesn't increase?
For this case, I believe it is set at 10%.
For each of the 3 rate years, correct?
Subject to check, but I can't remember. I'd have to go back in my notes of whether or not it was applied to all rate years or just the base case.
Thank you. No further questions.
All right, League.
Good afternoon, Mr. Williamson. Hi, I'm Ben Snowden here for the North Carolina League of Municipalities. And I'd like to ask some questions about the assignment of costs to the lighting class in general and especially to rate schedule SLS. So going back to the cost of service methodology, you testified that Duke Energy has relied on, or Duke Energy Progress and Duke Energy Carolinas have relied on a summer coincident peak methodology for their cost of service study in recent rate cases. Is that right?
I believe since 2012, both of them have used it.
Okay,
Prior to that, it was I believe Duke Energy Progress used the summer winter peaking average.
Thank you. With respect to the summer coincident peak methodology, the commission has approved the use of that methodology as reasonable in those prior rate cases, right?
Yes, the commission in every rate case deems the cost of service methodology appropriate until the next rate case.
And is it fair to say that reasonable minds can differ on what is the most appropriate cost of service methodology at a given time?
I believe that's why there are a number of cost of service methodologies, is that it's all dependent on a utility and a state and the policy and I guess most importantly, how the grid is planned, built, and operated. And if you follow that, I believe that you will come. If you follow where the utility is moving as far as how they are planning and building and operating their grid, it is more appropriate to have an energy allocation of some form in the cost of service methodology, and not solely based on the summer coincident peak.
Okay. And in the present case, in the present docket is the case that that both Duke and the public staff have changed their opinion since prior cases on the issue of what cost of service methodology is appropriate. Is that right?
As a part of settlement.
Okay.
And I
And so,
will note that the public staff has always advocated for an energy related or an energy component in its cost of service. And we signed on to this cost of service settlement because the modified average in excess does incorporate a version of an energy component.
thank you. And that modified average and excess methodology is used for the retail allocation among allocation among North Carolina retail ratepayers, right?
Yes, it is used to allocate the revenue requirement on the NC retail basis.
And use of the MAE methodology has resulted in a relatively greater proportion of costs being assigned to lighting class customers, correct?
I believe that the change in cost of service is changing the revenue responsibility of all classes. And so it's not just adding costs onto the lighting, it's changing the revenue responsibility for all classes.
Understood. But that reallocation among all classes has resulted in a larger allocation of costs to lighting class customers, correct?
That's correct.
Okay.
Can I add something to that?
Sure.
Sure. So the lighting class in particular, the reason they're experiencing such a drastic change is because of summer coincident peak changing to the modified average in excess. Under the summer coincident peak, when you're focusing on the 1 hour of the entire year where the peak was the highest in the summertime specifically, the lighting classes are not generally going to be on. I believe in company witness Hager, her direct testimony, she put a table, she has a table in her testimony that illustrates, I believe it's from the cost of service study. So it's 2018, 2019. It's not the current cost of service study test year, but it's an illustration across all years. But if you look at that, you can see that the summer coincident peak is typically going to be between 4 and 5 p.m. in the afternoon. And so at that time, lighting classes generally are not on. And so when you pick that particular hour, you're not going to be assigning a lot of costs to that lighting class in particular. And so by moving to this modified average in excess that, like I said, has an incorporation of an energy allocation, you're taking into account all hours of usage by every class. And so there's going to be an increase or decrease in revenue responsibility as a result of it.
Okay, so you would agree then that the reason that street lighting class customers and lighting class customers in general are shown as falling under the average rate of return is driven mainly by the change in methodology.
Yes.
Thank you. And the choice to recommend the MAE methodology for the first time ever in North Carolina was made in a settlement among Duke, the public staff, and Sigford too. Is that correct?
It was.
Okay. And this followed a stakeholder process that discussed several potential cost of service methodologies, right?
There were a lot of cost of service methodologies that were discussed and reviewed. And me personally, I took the cost of service study as an educational forum to all of the interveners as far as what cost of service methodology, what type of results are produced from from one cost of service methodology to the next, and why. And I believe in that study there was a list of pros and cons for each. And there's a lot of cost of service methodologies. It's just a matter of picking the one that most appropriately reflects how the utility is planning, building, and operating its grid.
And in that stakeholder process and in the report that followed, there was not a recommendation or a consensus on which methodology was most appropriate to use, was there?
Not to my knowledge, no.
Okay. Were all the stakeholders in that process invited to participate in the settlement negotiations that led to the stipulation?
I am unaware of who was asked to come to the table as far as settlements. That was above my pay grade.
Okay, and so you're not aware of who was informed of settlement negotiations?
I know who was. I know who signed the settlement settlement agreement.
Okay, thank you. And so you would agree that the selection of the MAE methodology was the result of the give and take of negotiations? That's what's said in your testimony, right? Okay. Is it possible that the choice of cost allocation methodology was somewhat influenced by who was sitting at the negotiation table and who was not?
Again, the settlement negotiations were above my pay grade, and so I was not at the table.
Okay, understood. Thank you. And we've had some testimony from you today in response to some questions by my colleague, Ms. Kress, about the 4 revenue assignment principles that the public staff follows. Is that right?
That's right.
Okay, and those principles are described in your testimony on pages 4 and 5 of your supplemental testimony, right?
I believe so.
And I'm correct that these 4 rate design principles are nothing new for the present case, are they?
No, we've the public staff has advocated these 4 rate apportionment principles for at least the last 3 cases.
Okay. And as you testified earlier, the first principle is that any revenue increase assigned to any customer class should be limited to no more than 2 percentage points greater than the overall jurisdictional revenue percentage increase. Is that correct?
That's correct.
Okay. And is this an embodiment of the principle of gradualism?
So while I do think that gradualism is important, however, the 2 percentage points, it's really a function of a particular class's increase. Take, for example, the lighting classes, like I was just describing. In previous rate cases under the summer coincident peak, they had a much lower revenue responsibility that was assigned to them, and now they have a higher revenue responsibility assigned to them under the modified average and excess. And so the reason that this rate principle was challenging to accomplish whenever I was creating my exhibits was because take for example the sports field lighting. It is a large increase. However, because of this change, the only way that particular class would have experienced less or would have stayed within that band, in alignment with that rate principle, I'll say, is if they received no increase. And that is purely a function of the volume of revenue assignment that is associated with that class.
I want to understand, I want to make sure I understand what you just said. You're saying, well, let me back up. You referenced sports field lighting, and you say that's a large increase. Large, you mean about 500%, right?
Yes.
Okay, and so you're saying it would have been impossible to design a rate that created less than a 500% increase in rates for that class?
Keeping all classes within the band of reasonableness under that modified average and excess cost of service methodology, the only way that the sports field lighting class would have complied with the first rate principle was to not have any increase assigned to them.
Well, a 2% increase, I'm sorry. So what was the average jurisdictional rate increase was about 6.7%, right? Or your recommended rather. And I'm sorry, I am looking at your corrected exhibit number 1.
Page 1,
Yes.
Okay.
Okay, are you with me?
on there,
Okay, so this is rate year 0.
correct.
And you see where it says in the first column, rate of return. This is NC retail 6.67%. Is that right?
That's correct.
Okay, so that's your recommended overall NC retail change in rate of return under this illustrative case. Is that right?
That's correct.
Okay. So within 2 points of that NC retail average would be an 8.67% increase for lighting or for sports field customers, right?
No, you're mistaken. What I'm talking about, the two percentage points is on the total percent increase, not the rate of return.
Okay, I'm sorry. I apologize. So yeah, on this, yeah, I misstated. So on this table, it's this 1.37% base revenue change. That's the overall increase for North Carolina retail customers.
Correct.
Okay, so within 2% of that would be a 3.37% increase, right?
Correct.
Okay, and instead, what is the increase that you recommend
For which one?
for sports field lighting?
Without the EDIT 4 credit, it is an increase of 586.45%.
Okay, so that's more than 3.37%, right?
That is.
Okay.
And
And
let me explain a little bit, is that I understand that that is a large, and that's kind of why that I'm using this as an illustration of what it would take in order to keep rates within, keep cross subsidization minimized. And so like I was saying, as long as it's in the band of reasonableness of that plus or minus 10%, the public staff doesn't view a class as paying more or less than its appropriate share. And so that was the challenge that was being experienced, is that because the bucket of sports field lighting, the dollars, the revenue responsibility for the sports field lighting was so small, any amount of dollar change was going to be a large percent increase.
And Mr. Williamson, you testified a few minutes ago, or actually I think just now, that in the public staff's view, if the subsidy is for plus or minus 10%, there's no subsidy effectively occurring, right?
We don't view any cross subsidization as occurring if it's within that band.
Okay, and in this exhibit, that rate of return index right there, that's, if I understand this, that's the ratio of the expected rate of return for that class to the average rate of return, right?
That's the illustration of that band of reasonableness that I was talking about. So 1 is the target, but if it's falling between 0.9 and 1.1, then it's falling within that band.
Okay, so there's no cross subsidization occurring essentially, right?
We don't believe that.
Okay, so what I'm hearing you say is that this 586% increase is what would be necessary for there to be zero or no effectively cross subsidization for sports field lighting in rate year 0, right?
For that snapshot in time, yes.
Okay. And so this is rate year 0, that's the base case, correct?
Correct.
Okay, so it's your recommendation that rates should be designed to achieve a complete elimination of cross subsidization in the first year of the rate case, right?
So elimination is not the word. Minimized to the greatest extent possible, I believe, is the phrasing that should be applied.
Okay, well, you just testified a moment ago that the public staff's view is that there is not effectively a cross subsidization if you're between 0.9 and 1.1 on this rate of return index, right?
Correct.
So 586% increase gets you to 1.02 rate of return index, right?
In this situation, yes.
Okay, so I guess I'm struggling to understand how you are balancing the first and second principles with these recommended allocations. How is the first principle, if at all, embodied in your recommended allocations?
So like I was saying before, under the modified average and excess for the sports field lighting class, because that's what we're talking about here, any amount of change in its revenue responsibility is going to be a larger increase in the as far as the base revenue change for that particular class. And so that's why I had to shift my focus away from that first rate principle and apply a greater focus on adhering to the rate of return band of reasonableness. And the reason I chose to do that was because of cost causation principle in HB 951 as it's defined in HB 951.
Okay, well, I'd like to circle back to that in a minute, but actually, let's talk about the statute for just a minute. You reference and you discussed this in your testimony, the cost causation principle in HB 951. Is that right?
I believe I do.
Okay. And we've discussed, you've cited previously in your testimony today what HB 951 says about the minimization of cross-subsidization. Do you recall that testimony?
Yes, I'm just trying to find where here it is. Found it. Sorry.
Okay. Mr. Williamson, would you agree, subject to check, that what HB 951 says is that interclass subsidization of ratepayers is minimized to the greatest extent practicable by the conclusion of the MYRP period?
Subject to check, yes.
Okay. So under this section, the commission should minimize interclass subsidization to the greatest extent practicable and also by the end of the MYRP period, right?
That is one of the challenges that the commission has in this case, yes.
Okay. So you would agree, wouldn't you, that under the statute, the commission's obligation isn't to completely eliminate interclass subsidization, but to minimize subsidization to the extent it's practicable to do so, right?
Objection. This is asking this witness, who is not a lawyer, to form a legal conclusion. Also, counsel has misstated the applicable standard from House Bill 951.
The witness has provided testimony in his direct testimony about what his obligation was under HB 951 and how he has applied it. So I think these questions are appropriate. I am happy to provide the statutory text, which I'm reading from, if that would be helpful.
I'm going to overrule the objection, ask the question again, and provide your answer, Mr. Williams.
Okay. I do have a copy of the PBR statute, if I may provide it to the witness.
Should be up there.
I imagine it's been provided already, but
I believe it's SIGFR 2 potential cross exhibit number 29.
or yeah, 26, I think, is the enrolled version of the bill. But yeah, if you've got that.
You said 29.
I'm sorry, 29. You were right. I'm wrong.
Okay. I'm at the definitions under part 2 of the law.
Okay, great. Thank you. And so you've got the definition of cost causation principle there. Could you please turn to page 4? That's the next page.
I'm there.
Okay, and you see subsection B there?
I do.
Okay. And I'll spare you my reading of the entire thing, but do you see down there, let's see here. Do you see where it says, no, I'm not going to spare you, sorry. It says the commission is authorized to approve performance-based regulation upon application of an electric public utility pursuant to the process and requirements of this section, so long as the commission allocates the electric public utility's total revenue requirement among customer classes based on the cost causation principle. Do you see that? I'll take a breath.
I do.
Okay. And do you see where it says, including the use of minimum system methodology by an electric public utility for the purpose of allocating distribution costs between customer classes? You see that?
I do see that.
Okay, and do you see it says an interclass subsidization of ratepayers is minimized to the greatest extent practicable by the conclusion of the MYRP period. Is that what the statute says?
That is what the statute says.
Okay, so would you agree that the commission is charged by HB 951 to eliminate interclass subsidization of ratepayers? Sorry, let me back up. Would you agree that the commission is charged by this statute to minimize interclass subsidization of ratepayers to the greatest extent practicable?
Yes, and that's why I said that that's the challenge that the commission has, is that they have to by law set rates that comply with both that statement, but also with the cost causation principle definition.
Okay, and do you see where, would you agree that the time frame for achieving this is by the conclusion of the MYRP period?
Yes.
Okay, thank you. Could you turn to page 7 of the document, please?
I'm there.
Okay, and you see we're subsection D1. You see that?
I do see that.
Okay, and do you see where it says, in reviewing any such PBR application under this section, the commission shall consider whether the PBR application, and I'm going to go down to little c here, will not unreasonably prejudice any class of electric customers and result in sudden substantial rate increases or rate shock to customers. Did I read that correctly?
You did read it, but I would also, I mean, I'm not an attorney, but I would say that I believe that this section, this D1 section, still allows the commission to have full range on whether or not it determines a rate or program of any kind, and proposed in this case to be reasonable and appropriate as it sees fit.
Okay, but I don't disagree with that at all. But would you agree that this requires the commission to consider whether the proposed rates would result in substantial rate increases or rate shock to customers?
They shall consider.
Okay, thank you. Let's go back to our discussion of the sports field lighting, just as an example. Is it your view that a 586% increase in rates for that customer class is not a sudden substantial increase?
I'm sorry, repeat your question.
Sure. So you recommend in your illustrative allocations a 586% increase in sports field lighting rates in the base case, right?
My illustrative exhibit about what it takes in order to achieve certain rate principles and cost of service methodologies, that's what it gets to.
Okay.
Yes.
Well, let me make sure I understand that too. And I understand that there are still questions about what the actual revenue requirements are going to be, and that my
Public staff is very much involved in reviewing the remainder of the case in order to come to a proposed final revenue requirement.
I understand that, yeah, these are just illustrative of how the public staff would propose to allocate rate increases given the assumptions about what those revenue requirements would be in total, right?
Yes, yes.
Okay. And that you had a very limited amount of time to come up with this, right?
So yes, I did have a limited amount of time, but I think I was able to put together a reasonable picture to the commission about the realities of what it would take in order to accomplish the band of reasonableness as far as cross subsidization in order to comply with 951.
Okay. Well, let me ask you this. Is it the public staff's position that the commission should approve an allocation of retail rate increases that achieves that 0.9 to 1.1 rate of return index in the first year of MYRP?
I believe that the the band of reasonableness should be applied to all rates that the commission is going to set when, as far as the revenue requirement and how it's apportioned.
Okay. Um,
However, I will say that uh, that gradualism is definitely something that should be taken into consideration. I do understand that for the sports field lighting in particular, it is at a potential to experience a very large increase, and that's something that needs to be taken into consideration as far as how would we handle that. And I don't know if that means I don't know if that means the commission allowing additional cross-subsidization to occur in order to mitigate that increase, or if it is a consideration of the commission to understand how we deal with the sports field lighting class because of its size and nature. One potential consideration could be to combine the class into another lighting class in order to smooth out those revenues and rate increases.
well, and let me move to outdoor lighting, to the SLS class here, because it's a little less of an outlier, I think. So for rate year one, the illustrative allocation base revenue change, and I'm sorry, I'm looking on page 2 of your exhibit 1 to your supplemental testimony. So
Just a moment.
sure.
You said exhibit 2, page 1?
I know, I'm sorry, exhibit 1, page 2. Just the next page, this is the illustrative allocation for rate year 1.
I'm there.
So you see that the illustrative allocation for sports field lighting is 598%, right?
Yes.
Give or take. And for outdoor lighting, SLS, the percent base revenue change is 33.85%, right?
That's correct.
Okay.
As you
that-
can see, the rate of return index is on the lower end of that band of reasonableness.
Mhm.
So
Understood, but it's within that band of reasonableness, right?
it is within that band of reasonableness, but any farther and it would go outside of the band of reasonableness. But the only way to decrease that 33% would be to go outside of that band of reasonableness.
Well, let me ask you this. Would a 33.85% increase in rates for that customer class not constitute a sudden and substantial increase?
If the commission deems those rates to that revenue requirement for that particular class to be appropriate and reasonable, I don't believe that it would be rate shock.
Okay, so it's your view that a 33.85% rate increase in a single year is not rate shock?
I don't know if I don't have I don't believe there's a proper definition of rate shock. I just believe that there's an understanding of what's a large increase and what's not a large increase. But for the 33% that's proposed here, like I said, that's just part of the math that came out of the cost of service methodology and the band of reasonableness.
Understood, and I understand it seems to me that there is a tension between gradualism on the one hand and getting rid of the cross-subsidization on the other hand. Would you agree with that?
There is a struggle with the gradualism, especially depending on the size of the customer class itself.
Mhm.
Like I was saying earlier, the smaller the revenues associated with that cost responsibility, the larger when revenue responsibility changes, especially if the previous revenue responsibility was smaller, you're going to experience an increase.
Right. It's not your view that, though, is it that what constitutes rate shock for a customer in a class depends on the total revenues for that class?
Could you restate your question?
Well, is it your view that whether a particular increase constitutes rate shock depends on the absolute dollar figure of the increase or the percentage increase?
I don't know what rate shock would be applied to. I assume it would be based off of the class's percentage increase.
Okay. And 2% is the benchmark percentage increase that the public staff has used in prior years to assess whether a particular increase constitutes rate shock, right?
It's one of the tools that we use, yes.
Okay. Has the public staff ever, to your knowledge, recommended a 33.85% increase to a particular customer class's rates in a single year?
To my knowledge, no. However, I would say that I'd have to get a better understanding of I guess, the impacts associated with the cost of service methodology being applied. Like I was saying, moving to a more energy allocation, non-coincident peak demand allocation is, in the public staff's view, more appropriate because of the considerations that it takes into account. And obviously, that's different from a summer coincident peak, where it's the different cost of service methodologies are not an attempt to punish or reward. It's an attempt to be as appropriate towards the system as possible. So whenever we advocate for this energy allocation, we think that it's the most appropriate component of a cost of service methodology. And we think that the modified average in excess encapsulates that.
Mr. Williamson, would you agree that in transitioning from a rate structure that's based on one cost of service methodology and the allocation that follows to a rate structure that is based on a different cost of service methodology, the commission should be especially careful about rate shock?
Yes, and the concept of gradualism needs to be taken into consideration. However, in this case, we have 3 years worth of rates that will be approved. And so there is an ability to incorporate a level of gradualism in rates as they're being increased. However, like I said earlier, with this particular class, because their revenues under the summer coincident peak are much smaller than the revenue responsibility they have under the modified average in excess, the only way to really keep them less than 2 percentage points of their class increase and stay within the band of reasonableness is to give them no increase at all. And I don't believe that that's fair or appropriate when in a general rate case, when costs are incremental costs are being applied.
Mr. Williamson, it is possible to assign a lower rate increase to a customer class that is still above the average retail rate increase, right?
I'm sorry, say that one more time.
Well, I think you just said that it simply wouldn't be possible to assign a smaller rate increase to, for example, the lighting class customers, but that's not really the case, is it? I mean, let me ask another way. If instead of being assigned a 33.85% rate increase in the first year, lighting class customers were assigned a 5% rate increase, it would be a rate increase. It just wouldn't get to the elimination of cross subsidies as quickly as a much larger increase, right?
If they were applied a 5% increase, I don't know what that would do as far as the rate of return. I haven't ran that analysis. However, I would like to point out that, just get back to it. In my supplemental testimony. So the third rate principle, I was asked earlier about what considerations were taken into account with regards to the other rate principles. And the third rate principle is to move closer into parity with the overall NC retail rate of return. And so a 5% increase specifically for that class, I don't know what that rate of return parity number would be as far as where they were at the beginning of this case and where that would put them. I don't know if that would move them closer or move them farther away.
Okay, understood. I guess my understanding would be that any increase, excuse me, in a particular class's rates that exceeds the average rate increase would tend to move them away from being subsidized, even if it wouldn't get them all the way there. Is that right?
If a class experiences an increase greater than the NC retail,
Yes.
they wouldn't experience cross subsidy. Is that what you're saying?
No, let me ask that again. That if a particular class gets a rate increase that's above the average, while it might not eliminate any cross subsidization, it would reduce that cross subsidization, at least incrementally, right?
If their rate of return is higher than the average, then my understanding is that they would be paying a higher revenue responsibility.
Okay. Mr. Williamson, in approving rates in this docket, do you think it is appropriate for the commission to balance as best it can those four principles that you've articulated?
So the public staff has always advocated, at least for the last three rate cases, that these rate principles be held to the greatest extent possible, be upheld. I do acknowledge that in this case there were a little bit of challenges, and so I had to reassess the principles. And because of HB 951 and its cost causation principle, I placed a greater focus on the second rate principle, which focuses on so I guess it's the second rate principle and the third, because it was an attempt to keep all of the rate of returns within the band of reasonableness to try and minimize the amount of cross subsidization that would occur, while also moving all of the classes closer to parity from where they were at the beginning of the case, which is typically one of the reactions of a rate case is the utilities, one, not recovering enough of its funds, but at the same time, it's a chance for rates to come in and get reevaluated as far as whether or not that class is paying a larger or smaller portion of its revenue responsibility to recover that revenue requirement.
Thank you, Mr. Williamson. I have just one more question. Just so I understand, is the public staff in your illustrative allocations recommending that Duke move more aggressively than it had proposed to eliminate cross subsidization among customer classes?
Move more aggressively to deal with cross subsidization? Is that what you said?
To address or to minimize, yeah.
So there are a lot of challenges that are going to be needed in order to for the commission to set rates that are appropriate in this case, and the revenue requirement that each class is going to be responsible for. How we get there. How we get there is going to be challenging. The commission is going to need to take into consideration all of the evidence that's been put forth on rates and the different scenarios that I've put forth and the different conditions that the company has put up. And I'm not aware of any other intervener that has proposed potential rates. So it's up to the commission to decide that and deem any level of cross subsidization as appropriate or reasonable.
Understood. Thank you. But how we get there, and there being minimizing cross subsidization, how we get there is important, right?
Yes.
Okay, all right. Thank you very much. Those are all the questions that I have.
All right, redirect.
Mr. Williamson, my microphone here. Ms. Kress asked you some questions about SIGFR potential cross exhibit 78. That was how was that exhibit was pre-identified, which is an NRRI report about alternative rate making mechanisms and their impact on economic efficiency. Do you remember that line of questioning in that document?
I do.
Were you previously familiar with that document or that report?
No, it was the first time I've seen that document.
But in reviewing that document, did it appear to you that the focus of that document was on natural gas rates as opposed to electric rates?
It appeared to be more focused on natural gas rates, yes.
And I'm sure that there are commonalities between electric rate design and gas rate design. But in terms of electric utility customers and gas utility customers, are you aware of differences in how those utilities users might respond differently to changes in price and how they might modify their consumption?
Sure. So they could implement energy efficiency. That's always a good first step. However, another avenue is kind of the distinctions between an electric customer and a natural gas customer. And when I say an electric customer and a natural gas customer, if you're a natural gas customer, you're automatically already an electric customer. So you're both. But if you're an electric customer, you're just electric. And so if rates go up in one area, say if rates go up in the electric space and you're an electric customer, you don't have anywhere to go. But if you're a natural gas customer, you could always switch that appliance over to natural gas and save and kind of curb your consumption towards another utility service.
Kind of in hearing your response there, are you saying that natural gas customers have more ability or more option to be more responsive to price changes than electric utility customers are?
They do.
Okay. And have you seen any evidence to suggest that the CAP program as proposed and as settled through the affordability stipulation would cause recipients to behave in a wasteful way, or as was referred to in that document as in an economically inefficient manner?
I haven't, but that's why in my direct testimony, I advocated that it would be considered as a pilot. And under the stipulation, that's where we came to, was for it to be approved as a pilot for a 3-year term. Under that pilot, we would be able to focus on where the benefits were, where any potential cost shifts might have occurred. One of the success metrics that I'll term it from the LIAC for this particular recommendation was decreases in disconnections and lower arrearages. And it's unknown at this time the extent of that level of decrease in disconnections or arrearages. And so as a pilot, we would be able to study those types of factors and come to the table in 3 years and discuss other options or opportunities to modify the requirements or modify the amount or modify the number of people that are eligible for it, or modify how the funds are distributed for that particular program. But until that data is kind of collected from this real world experience from this program, we just don't know at the time.
Mr. Williamson, based on your review of the CAP program, does the CAP program have the potential to offer system-wide benefits that would benefit all rate classes over the pilot period?
It does. Customer defaults on bills or non-payments or uncollectibles, I guess is the proper term, essentially get rolled up into a rate case and collected from all customers. And so as that decreases, it would provide a reduction in the total bills that are required to be recovered through the revenue requirement.
And if I'm hearing you that has the potential to lower the revenue requirement, does that mean that would have a downward effect on rate classes, rates that would be set.
A lower revenue requirement than what would have been, it would be a decrease in rates.
And we talked about, you were also asked some questions about SIGFR potential cross exhibit 79. Do you recall that line of questioning?
I might need to refresh myself with what document that was. $79?
Yes, I can, if you bear with me just a second, I can pull up my. 79 was the document from Kenneth Costello from the University of Pennsylvania, titled Making Utility Assistance of Low to Low Income Households More Effective. Do you recall that particular document?
Yes, I've got it right here.
And had you previously had the opportunity to review that document, or were you previously familiar with that document?
No, but I will say that it was filed under an opinion article.
Ms. Kress asked you a question or some questions about discriminatory pricing. Do you recall that line of questions?
I do.
Do the general statutes mandate that no discriminatory rates can occur, or is it just that the commission should avoid unjust discrimination?
So it just, my understanding is that they are to minimize to the greatest extent possible any cross subsidization that would occur, and any rate that the commission approves would fall under that category of being reasonable and appropriate.
Would you agree that discriminatory pricing occurs when one customer or group of customers pay for the costs caused by other customers or groups of customers?
Can you repeat it?
Yeah. Would you agree that discriminatory pricing occurs when one customer or a group of customers pays for the costs that were caused by other customers or groups of customers?
If it's unjustified, then yes.
And is it possible for a utility to design perfect rates from a cost causation standpoint?
No, and that's why I wanted to bring up the Read Exhibit 10 and how the rate of return graph that's illustrated there, and how rate of return for was it 4 different classes have changed from year to year, and how when we set rates, we're picking a snapshot in time in order to use as our guide to set rates for the future until the next rate case is filed.
I'd like to ask you what you mean by snapshot in time. Would having Read Exhibit 10 be helpful to you in illustrating that testimony?
Sure.
This was already previously admitted through the direct testimony of Teresa Reed. Do you have that document in front of you? Or if not, can I, for convenience, bring it to you?
I'm going to object because the only questions that were asked on cross pertaining to Ms. Reed were different exhibits. This witness was not asked about Exhibit 10.
And this is in response to the general line of questions that was asked about discriminatory pricing as well as interclass cross subsidizations.
All right, I will overrule the objection. I'll allow you to approach, get the document in front of your witness.
Would you like to see the document? Yeah. And so when you were just given your previous answer and referenced this exhibit, you talked about this being based on a snapshot in time. What did you mean by that?
So every cost of service is going to have a test period of a calendar year, hopefully. That's what's been represented here, it looks like, as far as the rate of returns from 2008 all the way to 2021 for the residential, small general service, medium general service, and large general service. And so when you look at how we have progressed since 2008, you can see that all 4 rate classes have spent time both above, below, and within this dotted line band as far as a percentage of rate of return based on the NC retail. And so what that tells me is that for that particular year, certain classes outside of the band were either being subsidized or so they were either paying more than their fair share or paying an insufficient amount of their revenue responsibility. And so the goal is to keep all classes within that band. But as you can see, that it's really a moving target. It's just an understanding of how costs were incurred during that time period, as far as how the cost of service uses that test year.
And just for reference, when would the last Duke Energy Progress rate case, where would that have fallen on this chart? The rates that were set by that?
I believe it was filed in 2019, but I think those rates went into effect in 2020,
And
subject to check.
then prior to the one you just referenced, when would the previous rate case have been before that one?
16 rate effective for 17, I believe, subject to check.
So then is it fair to say that the actual realized rates of returns between rate cases will tend to fluctuate?
They do fluctuate. As you can see, just between the rate cases of the 2016, 2017 rate case to the 2019, 2020, a lot of the classes or all of the classes are not in the same place that they were the year prior.
Let's move on and talk about your supplemental exhibits that were referenced by Ms. Kress. Are those supplemental, those charts that were contained in supplemental exhibit 2? I don't think you need to turn to those exhibits, but is that a format of an exhibit that the public staff always presents in a electric general rate case proceeding?
It is. It's just an illustration to the commission under these different scenarios so that they have an understanding of revenue requirement impacts associated with, like I was saying, no increase or equal to the NC retail increase, or under the public staff's traditionally proposed allocation and equal rates allocation. So it's to provide an illustrative perspective to the commission so they can get a viewpoint of what the impacts could be under different scenarios.
I think you were asked a question about, well, really from both parties about the topic of rate shock, but specifically you were asked from Ms. Kress if 1/2 of 1% of a rate increase is rate shock. Do you recall that question?
I do.
And in response to both lines of questions about rate shock, to your knowledge, is there a statutory or a rule definition of rate shock that is applicable to the commission?
Not to my knowledge, no. I believe in every case they have to analyze the case that's in front of them and the situations that are the different proposals that are in front of them and analyze what's reasonable and appropriate.
Is it your belief that that is within the commission's discretion to determine?
It is.
You were also asked some questions from Ms. Kress about the public staff's principles for revenue apportionment. And I think about the weight or the priority that you gave to those principles. Do you recall that line of questioning?
I do.
Is it possible for the public staff to apply a hard and fast kind of formulaic approach to revenue apportionment? Or is that practice more of an art, I guess, for lack of a better word, when revenues and rate making must come into play?
It is kind of a form of art. One of the reasons the public staff put forth these rate principles was to not only help the public staff, but to help the commission come up with a means of coming to a level of appropriate and reasonable whenever they're determining these rates and being able to justify the types of increases that individual classes might be experiencing.
I think you had some questions from both parties here today, but in terms of your supplemental testimony and your exhibits there too, just to clear it up for the record, is the public staff making specific recommendations from a rates and revenue standpoint at this time?
No, we're not. We're still we're still reviewing the final supplemental update that was filed not too long ago. We're still have some discovery out, and like I was discussing earlier on, and kind of earlier on, kind of an iterative process. The project plant related folks on the public staff's team are still reviewing individual projects from all across, and they'll provide accounting with the final recommendations that they've come up with, and the county will then roll that into their final schedules and be able to put forth a final revenue requirement proposed by the public staff.
And not to fault Mr. Snowden or Ms. Kress, with when their questioning was asking about the recommendations that were previously contained in your testimony, but are now for illustrative purposes. But was it your intent in responding to those questions to indicate that any of these any of the charts contained in your supplemental testimony are actual recommendations? Was that your intent in testifying today?
No, it's not. Like I said, it's just an illustration to the commission so they can understand different perspectives.
Okay. Moving on to a different subject now about the cost of service methodologies. And Mr. Williamson, to your knowledge, is there any statute or rule that restricts the commission from switching from one cost of service methodology to another in a rate case, and say, for example, from a summer CP to what's been proposed in the cost of service agreement?
No, there's no law preventing it. That's why we have a lot of different versions of cost of service methodologies. It's all about which is the most appropriate, and in every rate case, there's going to be a cost of service applied, and so it just depends on the case. But like I've said here today, I'd place a lot of focus on how the utility is planning, building, and operating its grid today. So it's all hours should be taken into consideration whenever costs are being associated.
You were asking a number of questions about relative to the changes that were illustrated in your exhibits to the different classes of lighting, the lighting schedules. Do you recall that line of questioning?
I do.
Is it fair to say that reducing one class's apportioned rate of return for the purposes of lowering the rates that they would pay, is it fair to say that that would result in those production plant costs being shifted to other rate classes?
Can you ask the question again? Sorry.
Yeah, and let me split it up. I guess in as part of a cost of service, that's allocating, at least in part, a production of, or a portion of production plant. Isn't that right?
That's correct.
Okay. And so when you are assigning class rates of return from the cost of service study, if you then, after completing that process, choose to reduce one class's rate of return, would that result in other rate classes paying for the subsidized classes' production plant costs, or at least a portion of them?
So like what we were saying earlier, the rate design piece is a little bit of an art. That's why we applied all these rate principles in addition to the cost of service that's used as kind of a guide. But as long as all the revenues for individual classes allow the rate of returns to stay within that band of reasonableness, there's an ability to recover costs in that way. Yeah.
No further questions.
All right, questions from commissioners. Commissioner Brownbland, Commissioner Claufelter? Okay. Go ahead, Commissioner Duffley.
Good afternoon. I just have one small clarification question, and it's on page 10 of your direct testimony. So on lines 7 and 8, you in the sentence saying that the estimate that this estimate is considered basically reasonable given the uncertainty associated with initial eligibility. Could you just more fully explain what you mean with the words uncertainty associated with initial eligibility? And you're talking about the estimate, I don't know if that's a confidential number, but this estimate of 60,000 customers. And then the cost estimate that goes with that.
Sure. So through the LIAC, there was a proposed number of customers that would, under that snapshot in time in the LIAC, would be considered SIP or LIHEAP eligible. And in this case, the Duke Energy Progress has proposed 60,000 as kind of a baseline for potential customers. And so whenever we reached out to the North Carolina DHHS in order to get a better understanding of the number of applicants and that are filing to become eligible for this SIP and LIHEAP. That the information provided from DHHS kind of fell in line with the company's proposal. I think the uncertainty associated with initial eligibility, I think that falls under the guardrails of what 60,000 customers is. I guess what I'm talking about is right now eligibility is dependent on DHHS. And so one of the concerns that we had was what happens if it turns into 120,000 or 400,000 or 800,000 customers? I think that would be a cause for the public staff to reevaluate this program and see what needs to be done to provide some revisions to it. And so that's kind of one of the reasons why we proposed a pilot. Again, it's just to reevaluate at the end of the 3 years to try and get an understanding of what customers are being impacted, what's the real expected participation from this program from customer or citizens of North Carolina that apply to DHHS that are under SIP or LIHEAP that are also Duke Energy Progress customers.
Okay, that answered it. So it's a forward-looking uncertainty, not an uncertainty for
Correct.
purposes of the pilot.
Yeah, we think that the 60,000 that they've proposed right now is a rough estimate, is reasonable.
Okay, thank you for that.
All right, any additional questions from commissioners? Okay. Questions on commissioners' questions? All right. All right, Mr. Williamson, thank you for your work in this case and for your testimony before us. You may step down and you are also excused.
Thank you.
Chair Mitchell, I'm sorry, but SIGFR 2 would like to reserve the right to cross-examine Mr. Williamson on any additional supplemental testimony that he might be filing in this rate case. So for that reason, we would object to Mr. Williamson being excused.
All right. I will hold on that motion. Also on, I will hold in responding to your motion. Also, thank you for, and I will also hold on excusing you, Mr. Williamson, pending decision on your motion.
Thank you.
All right. I'll take motions related to Mr. Williamson's testimony.
Thank you, Chair Mitchell. The public staff would move that the exhibits attached to the pre-filed supplemental testimony of Mr. Williamson be entered into the record and marked for identification as pre-marked. And that was public staff Williamson D supplemental testimony exhibits 1 and 2.
All right, that motion is allowed. Ms. Kress?
SIGFR 2 would move the admission into evidence of its SIGFR 2 cross-examination, D. Williamson, direct settlement and supplemental exhibits 1 through 3.
All right, that motion is allowed as well.
Thank you.
All right, Mr. Williamson, you may step down, sir.
Thank
you. All right. We will, public staff, you may call your next witness.
Public staff calls Jordan Nader.
All right, Mr. Nader. When you get settled, there you go. Raise your right hand, please, sir. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
Mr. Nader, would you please state your name, business address, and current position for the record?
My name is Jordan Nader. My business address is 430 Salisbury Street, Raleigh, North Carolina. My position is a engineer with the Public Staff Energy Division.
And on March 27, 2023, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 26 pages and 1 appendix?
Yes.
Do you have any changes or corrections to your pre-filed direct testimony?
No.
If you were asked the same questions today, would your answers be the same?
Yes.
And did you also prepare and cause to be pre-filed on May 4, 2023, a summary of your testimony in docket number E-2 sub 1300A?
Yes.
And Chair Mitchell, I understand that his testimony and summary of testimony have already been entered into the record.
They have been.
And Mr. Nader is available for questions.
All right. My notes indicate no cross-examination for this witness, so we will, I will check in with commissioners, beginning with Commissioner Brownland, Commissioner Kleinfelter.
Mr. Nader, just a couple of questions for you. The methodology under the proposed rider NSC for netting imports and exports from and to the grid is a different methodology than the one that is used for the residential NEM tariff. I understand the difference. I don't need an explanation of the difference. What I need to hear you talk to me about is the public staff's view of the reasons why such a differential netting methodology are justified.
So I will say that I did not work closely on the residential NEM tariff, so I can't speak in great detail to the differences or the benefits to the system. In reviewing rider NSC, I think the company's proposal represents a reasonable balance of risk and reward to the customer who elects to install that behind the meter generation. But like I said, I was not intimately familiar with the residential net metering proposal, so I really wouldn't be able to speak to the differences there. Sorry.
That's a fair answer. So I take it if I were to ask you then why it wouldn't have been equally useful or plausible or beneficial to use a kind of with a pour over concept for the netting in the residential tariff, you would not be able to speak to that question.
I wouldn't want to speak to that without reviewing it.
That's a fair answer. The issue that was of considerable interest, again, with respect to the residential NEM tariff, was the issue of subsidization of NEM ratepayers by non-NEM ratepayers. Did the public staff make any assessment with respect to rider NSC of any issues or risks about subsidization between ratepayers who might be on rider NSC and ratepayers who are not on rider NSC, commercial and industrial ratepayers not on NSC?
Right. So in conversations with the company, part of the ability to mitigate is derived from the demand-based charges. So because the demand, as proposed, if rider NSC goes into effect on October 1st, any customer starting October 1st, would be on a time of use rate with a demand-based charge. And so that would help to mitigate any material cross-subsidization between a commercial customer or large industrial customer and their peers within the rate class. The company did propose to, recognizing that for planning purposes, customers who have a proposed generation below 60% capacity factor, if they are on this proposed rider NSC, they'll pay a demand charge. That should cover the standby component. And so those customers will not be required to pay the standby charges that are typically associated with being on, with being larger than 100 kW of behind the meter generation under the current non-residential standard, if that makes sense.
It does. And so that feature would also mitigate any risks of subsidization with non-RSC C&I ratepayers.
That is my understanding, yes.
Thank you for your succinct explanations. That's all I have.
Good afternoon. So on page 11 of your testimony, you made a recommendation. I don't think you need to go to it, but you're welcome to. That the commission authorize a deferral if the commission authorizes a deferral of the impacts associated with the IRA, that it also authorizes a deferral for the impacts associated with the IIJA. And in rebuttal, DEP witness Abernathy agrees to this recommendation. Is that correct? I'm just getting this agreement on the record.
Yeah, so I agree that witness Abernathy agreed with the recommendation. I think I would say that perhaps my language was unclear in my direct. What I was attempting to convey was that the treatment of the IRA should be substantially similar to the treatment of the IIJA. And so the initial request of the company was in regards to the IRA. If you determine that that treatment is appropriate for the IRA, we should treat the IIJA the same way. There are many differences between the two federal laws, but in general, the way that the benefits would flow to North Carolina ratepayers will be similar. And so any treatment of the one law should be apportioned to the other. But I don't want the commission to think that I'm making an accounting recommendation by any means. I'll leave that to the accountants of the public staff.
Correct. I did not take it that way. Okay, thank you. That was my only question.
All right, any additional questions? Questions on commissioners' questions? Okay. All right, Mr. Nader, you may step down, and you are, you may step down. Thank you for your participation in this case. All right, Ms. Laura, we've taken care of this witnesses' exhibits.
That's correct. You had no exhibit.
Okay. All right. At this point, we will turn to the company for its rebuttal case.
Thank you, Chair Mitchell. This time, DEP calls back to the witness stand Mrs. Kendall Bowman.
All right, Ms. Bowman, good afternoon. Just a reminder, you remain under oath.
Thank you. Ms. Bowman, this time, would you please once again state your name and business address for the record?
Kendall Bowman, 411 South Wilmington Street, Raleigh, North Carolina.
And Ms. Bowman, did you previously testify in the direct phase of this proceeding?
Yes, I did.
Thank you. And on April 14th, did you cause to be pre-filed rebuttal testimony consisting of 27 pages?
Yes, I did.
And on May 10th, did you cause to be pre-filed a summation of your rebuttal testimony?
Yes.
On May 15th, did you also cause to be filed a single correction to your pre-filed rebuttal testimony?
Yes.
And with that correction, if I were to ask you the same questions today under oath, would your answers be the same as are set forth in that pre-filed rebuttal testimony and summation?
Yes.
Chair Mitchell, at this time, I would ask that Ms. Bowman's pre-filed rebuttal testimony and summation be entered into the record as if given orally here today.
All right, the rebuttal testimony of DEP witness Bowman filed in the docket on April 14th, 2023. and corrected on May 15th, 2023, consisting of 27 pages, will be copied into the record as if given orally from the stand. The one exhibit to that testimony will be marked for identification as was when pre-filed, and the summary of her testimony will be copied into the record as if given orally from the stand as well.
Thank you very much, Chair Mitchell. With that, Ms. Bowman is now available for cross-examination.
All right, Sigfer, you're up.
Thank you, Chair Mitchell. Good afternoon, Ms. Bowman.
Good afternoon.
Do you recall when you were here testifying on direct that you listed a couple of ways that rate mitigation could apply to industrial customers of DEP?
Yes.
And did you hear the testimony provided by KUKA witness Helig?
Yes, I heard part of that testimony.
Did you hear some questions asked of witness Helig pertaining to what this commission could do to help ease the impacts of the rate increases being proposed in this rate case?
What specifically are you referencing?
Yeah, and so there's not, at least I don't believe there's a transcript yet. So I'm asking if you recall any questions being asked of witness Helig pertaining to what this commission can do to help assist the rate impacts associated with this rate case.
I remember discussion about the job retention rider, the economic development rider, or are those the programs you're referencing?
So thank you for confirming that you do recall that line of questioning. Ms. Bowman, isn't one thing that this commission could do simply retaining the equal percentage method of allocating fuel costs?
I believe that that was one of those that I had referenced as something that the companies have done, and we've done it for over a decade. I think we heard some discussion this morning about that program as well. And that was done as a way to help our large industrial customers.
And if that program were to discontinue, that would harm industrial customers, correct?
I think they would see potentially an increase in fuel.
And so would you agree with me that it would help to mitigate the rate impact associated with this rate case if the equal percentage method were continued?
I think for industrial customers, it would be seen as helping reduce their fuel component if it were to continue.
Thank you. No further questions.
All right, CUCA.
Chair Mitchell, CUCA has no questions for the witness.
All right, public staff.
The public staff has no questions.
All right, commissioners. Commissioner Brownbland. Commissioner Flackleton. Duffley? Okay, anybody? All right, Ms. Bowman. I have a few for you, so. You don't get off that easy. All right, and I'll start, and we're gonna take a break at 3. So I'll we'll get as far as we can, and then we'll take a quick break. All right, page 9 of your rebuttal. You don't have to go there, but you can if you want to. You talk about requirements imposed on the company that increase risk to the company. I think you identify them as execution risks. You remember that testimony?
On page 9 of my,
Yeah,
I remember listing lots of potential challenges and
Yes.
risks to the company. Yes.
All right, just let me get there with you, but take a minute and look at it. All right, have you had a minute to look at
Yes.
it? Okay,
Mhm.
so there's been a lot of back and forth during this proceeding on risks to the company and and sort of how the multi-year rate plan mechanism factors into the company's mitigation of those risks or sort of risks as they impact the company. So can you, for a minute, talk about the execution risks that the company faces right now and sort of looking forward, both the next 3 years and beyond, let's say the next 10 years? How, this is my question for you. Without the multi-year rate plan, how does the company fare as it attempts to address the execution risks that you're aware of at this point in time?
So let me step back and just kind of give you a perspective that I see as the state president for Duke Energy here in North Carolina of what we're facing. I think we're in a sea change right now, actually in the whole entire electric industry, if you think about it. But for North Carolina, as we're implementing this clean energy transition, that brings along with it additional execution issues. In addition to that, we're looking at physical security, and we've got some of that built into this case. I think we all experienced the Moore County substation shooting. We've seen that increase in the industry. There's cybersecurity that we deal with and contend with every day. We're also facing increased weather events, more intense weather events than we've usually experienced before. We're also looking at the electrification of the transportation sector, which is a good thing, which is a great thing, but it is going to bring with it some unique challenges to the company. In addition, we're looking at transitioning our coal fleet, really retiring that coal fleet and replacing it with new generation and really trying to achieve the state energy goals of clean energy going forward. Along with that, we're going to be constructing all kinds of new renewables. I think we're looking at, anywhere from about 8 gigawatts of new renewables by 2030. And we're looking at transmission and distribution infrastructure. And anytime you build any infrastructure, it's faced with all sorts of permitting and siting challenges and risks along with that. I think of the word NIMBY. I don't know if you remember the Not in My Backyard. That acronym has now changed to BANANA. What is it? Build absolutely nothing anywhere near anyone. So the challenges of just constructing anything have increased tremendously. And we're going to have to be constructing a lot as the policy goals set by 951 are going to require us to do. And even without 951, we were going to need to be constructing a lot to replace our aging infrastructure. So there is a tremendous amount of challenges or opportunities that we face as a company. And I believe that the PBR and multi-year rate plan that was passed in 951 is going to afford us a better opportunity to go out into those financial markets to attract the capital that we need to invest in this state at a lower cost for our customers. So I think that multi-year rate plan and PBR benefit the customers of North Carolina by allowing us this regulatory certainty and that financial flexibility in those markets.
All right, thank you, Ms. Bowman. Can you say more about what the multi-year rate plan affords the company and then ultimately its customers? I mean, I believe your testimony characterizes the multi-year rate plan as a modernized rate making paradigm. And if you didn't use that word, then I'm paraphrasing it. But what does it afford you all that that the company wasn't able to achieve with the historic or the traditional rate making tool that had been available to the company?
Well, it
in North Carolina.
it affords us the opportunity to get in line with the rest of the country. And as witness Bateman, I believe we filed a supplemental exhibit that talks about where the rest of the country is in terms of alternate rate making, multi-year rate plan riders, and the sort. So the financial markets look at all of that, and MYRP and PBR here in North Carolina puts us kind of on a level playing field with the others in the marketplace. Plus, it also allows us the ability to to look out and plan some of those assets in the near-term horizon and get stakeholder input along that process. I believe we held technical conferences before this proceeding here, talking about the projections that we need to make in the next several years in the multi-year rate plan.
All right, and talk some about what do the next couple of years look like for the company and for its customers? Were this commission not to approve a multi-year rate plan?
We would likely be filing a rate case every single year if we were to not approve this multi-year rate plan.
All right. There's been some discussion during significant discussion during the course of this proceeding about the non-multi-year rate plan capital investment the company plans to make. Have you followed that?
I do.
Okay, discussion, and you know what I'm referring to. Explain to us how the company is going to manage that challenge, both in terms of ensuring that its financial health and soundness doesn't deteriorate, as well as, what are we going to be, how are you all going to manage the burden that could impose on customers going forward?
So I'll speak to that at a high level, and Witness Bateman could perhaps get into some of the more technical mechanics of it. But, not every capital spend is the same. Not all of that will go into plant and service at the same time. Some of that would likely need to come in the next multi-year rate plan, perhaps. Some of it could be chunky and large generating assets where we are allowed to get AFUDC. So there's things and mechanisms in place that could help the company manage, but that is going to be a risk that the company will be able to take on.
Okay. And so I assume your testimony is that the company will be able to manage, there are tools available to the company or mechanisms available to the company, accounting mechanisms available to the company to help the company manage its own financial soundness as well as ultimate impact to customers.
Yes, and I think Witness Bateman can provide some mechanics.
Okay. Let's see. You just heard Mr. Nader's testimony about the impacts of the two recent federal pieces of federal legislation on involving tax programs for energy projects, IIJA and IRA.
Yes.
Yeah. Okay. And Commissioner Duffley asked him some questions about deferring the impacts of the IIJA in addition to the IRA. Is that the company's intention?
Yes.
Okay. And is it the company's intention to identify and pursue as many opportunities under both of those federal enactments that would provide benefits to customers as possible? Let me ask that question differently.
Yeah.
Is it the company's intention to pursue as many programs available to it under the IIJA and under the IRA as it can, so that benefits to customers will be maximized?
Yes, it is.
Okay.
And I believe there is another docket. And we just recently filed, I think, a status report on IIJA and all of those offerings that we are going after. We are trying to seek every dollar that we can. We may not win everything because it is a bid and we're competing against all of the other states and utilities in the country. But we are definitely going after every dollar, and we will try to maximize every dollar we can under the IRA as well.
Okay. Let's take a break here, and we will go back on the record at 3:20. Let's go off the record, please. 3:20, yeah. All right, Ms. Bowman, just a few more questions for you. Page 14 of your rebuttal testimony, you discuss the company's stakeholder engagement in certain areas
Yes.
over the past couple of years. And, you know, by my count, there have been 7 stipulations, settlement agreements. Is that correct? 7 so far?
Subject to check, yes.
All right. And 6 of those have come in after after the company filed its rebuttal testimony. So talk some about sort of the company's engagement with its stakeholders, particularly with its customers during this case and in recent years leading up to this case. And in my view, in my view of the testimony that we receive from all stakeholders, some we hear complaints and criticisms of the process, and we hear endorsements of the process as well. So I'd like for you to discuss sort of the effort and resources that the company has put in relative to what you all have achieved in this case.
Well, first, I would start with, I think we have put in place more stakeholder outreach, stakeholder discussions with our customers than any other prior rate case that I've been involved with. And I'll probably start with the low-income collaborative, because that was a notion that was coming out of the last rate case. That was a year-long collaborative. We've heard a lot of discussion about it today, but we really worked closely with those stakeholders. I think there was a lot of consensus. There's a report out there in the docket, got a lot of great ideas that are stemming from that, not just the customer assistance program, but some of the low income weatherization DSM programs out there. Really productive discussion with stakeholders. You've also heard about the comprehensive rate design study. Again, another year-long process, a lot of collaboration with stakeholders involved in that. A lot of what you've seen in terms of the rate design that we filed in this case resulted from that rate design study. And I think you heard witnesses Bird and Reed talk to that effect. We also did a lot of work around PIMS, stakeholder engagement. You know, this was the first of its kind for North Carolina. We spent a year working on the governor's clean energy plan in 2020, where PIMS was discussed and talked about there. Then when we had the passage of 951 and we knew we were going to be filing this case, we actually had some stakeholder meetings, really tried to get feedback and input from what stakeholders and customers want, realizing we're not going to make everybody happy, but I've been very pleased with the PIMS settlement that we've pulled together, and I believe we did it in record time. If you look at other states across the country where they've kind of started with just tracking mechanisms before they moved into any full-blown PIMS. And so I think we've got a little bit of both here, and it's kind of a walk before you run. But I feel like the stakeholder outreach we've had has culminated in some really positive settlements. Did we get everything everybody wants? No, but we certainly did get a lot out there, and I think we've proposed some really good PIMS in this proceeding. We've also had engagement with our large industrial customers. We had a cost of service settlement with some of our large industrial customers and the public staff preceding this, and preceding, I think, even the revenue settlement that we reached with public staff first. We also had the transmission and distribution technical conferences that I talked about. We've also had other stakeholder engagements along the way. When specific questions come up with customers, we try to routinely go out and meet with them. Quite frankly, I would like to applaud the work that the public staff has done in this case. I know what you're hearing is those areas where we didn't agree on, but we did agree on a lot of areas. And that's in large part to the due diligence that they conducted. I think we responded to over 12,000 data requests in this proceeding. I think that breaks some kind of a record. I think that was more than the previous rate case. I think it was more than the carbon plan proceeding, which I thought was one of the most complex proceedings I've been through. But also many of the other interveners and stakeholders of this proceeding, we've been able to reach settlements with as well. I think that's in large part due to the stakeholder outreach we've had over the past several years. I think it's something that we would like to employ going forward. I think it has significantly reduced the hearing time in front of you. I mean, we may not think it today since we've been in here for a while, but I think it's those that all you hear in here is the areas that we don't agree on, but there have been a tremendous amount of areas where we have agreed on. So I would like to applaud many of the interveners and the public staff in this proceeding.
All right, thank you for that. All right, let's turn for a moment to your testimony, your rebuttal testimony, starting on page around 17 and 18. You discussed the supplemental update process that you all have employed or have been working through in this case. The company and the public staff has the sort of post filing of your rebuttal testimony. Have you all resolved the updates?
Yes.
Situation?
I believe we have, and I believe witness Boswell said so when she was testifying. the other
Okay,
week.
so
I
you
think- mhm.
you heard her testimony and
Yes.
you agree with it. Okay, so it sounds like you all are at least on the same page and moving forward. And Ms. Boswell said they're working on reviewing, auditing your final update
Correct.
that was filed from, I guess, around mid-April. And to the extent that they are awaiting on responses from the company, just ask that the company move forward with those as quickly as possible so that
We are
can
working as fast as we can. We
get all of
understand they
that
need
into
to
the
get it.
Okay. All right. Do you have any thoughts for improving the update process? I mean, it creates a difficult situation when we don't have record evidence prior to the start of the hearing, and here we're sort of looking at we're nearing the close of this hearing, and we don't have certain evidence before us. Is there anything we can do going forward to avoid this?
I think that's something we can certainly think about and try to revisit. I think we faced this issue probably in every case we're in. I think this one in particular was a challenge because it's the first time we've ever done the multi-year rate plan. I am optimistic that getting this first one behind us, we will all learn and improve upon that. We will try to endeavor to be able to update as fast as we can, realizing that the public staff does need to complete audits. I will say we did reach an agreement on when the cutoff date would be in both this case and the DEC case, but it's something that we'll think about and see if we can come up with ways to try to mitigate this issue.
Okay. All right. Thank you, Ms. Bowman, for your testimony. Let me see if there are questions from other commissioners. Bromland. Okay. Gladfelter. Okay. Definitely. Okay. Go ahead. Commissioner McKissick.
Thank you, Chair Mitchell. Just one or two questions, and it goes to your rebuttal testimony. I guess it's about 27 pages, and it's about 6 pages dedicated to what's referred to as kind of miscellaneous issues, which have a lot to do with what I call workforce diversity and supplier diversity and things of that sort. And I guess want to understand what your targets may be in terms of workforce diversity or goals or programs or strategies, and likewise for supplier diversity. If you could speak to that, since you dedicated over a quarter of your rebuttal testimony to those issues.
Yes, absolutely. And I believe we were responding to a Sierra Club witness, Roger Colton.
Yes.
And I think, he was specifically asking for more workforce diversity in the energy industry and in particular around energy efficiency. And so here I was highlighting all of the various efforts that the company has. And we at Duke Energy really take workforce diversity seriously, both for our own employment, but for our supplier diversity as well. In fact, I credit this commission. Y'all have the North Carolina hire rule out there, and we file reports every year with you all talking about our supplier diversity and our desire to recruit local suppliers in North Carolina, but also diverse and minority-owned suppliers in the state of North Carolina. So this is just kind of highlighting some of those programs. But in addition, we also are looking at diversity amongst our workforce, and we need to train a workforce. We need to go out there and train this workforce. We were just talking about all of the infrastructure that we're going to be constructing, the new technologies that are out there. We're going to need a workforce to do all of this. And so we partner with a lot of our universities and community colleges. You know, I reference an E-4 Carolina's HBCU Energy Leadership Pathway that we have sponsored, working with some of our key HBCUs here in North Carolina. And also I reference the work that we do at our community colleges on line worker training. We always are continuously looking for new line workers in the industry. They're hard to come by these days, so we're continually partnering there. We also have diversity goals for our supply chain. So in addition to the North Carolina hire, this is just a corporate wide. It's not just North Carolina specific, but we have supply chain diversity goals as well. So it is a top priority for Duke Energy.
Do you recall what those goals or targets may be? I mean, understanding they're aspirational.
I think we do have some percentage targets, but I do not know those off the top of my head. If that's something you're interested in, we could.
Could you provide them in
We
a
could
late
provide
file
it.
exhibit?
Yes.
That would be appreciated. And I noticed, I think it's on page 24, you talk about spending $4 billion during 2021, and like 1.5 billion was with diverse local suppliers, and likewise what contractors you had Duke had done business with reported as those prime contractors reporting what subcontracting had been done.
Yes.
Is there a specific way that that is tracked, or is that something you could also include in that lake file exhibit?
Yes, if we have that available, we will include.
But that would be helpful. And I noticed there was one thing on page 25. It said, do you agree with Witness Colton's recommendation that the commission should direct Duke to develop a plan to promote work diversity? And of course, the response was actually no. So I'd like you to, speak to that a little bit more if you could.
I think the reason it is no is that we already have a plan in place at Duke Energy to promote workforce diversity and also to promote supplier diversity. So I think that's why you saw it, it was followed by, we don't think there needs to be another separate plan put in place around that because we were already doing that work.
Okay. Well, and I guess the last question would be dealing with what is referred to environmental justice. And you identify, I guess, some recent ongoing initiatives that have been begun. Could you speak to those a little bit more?
Absolutely. And I think you're referring to my testimony on page 26. So
that is correct. Yes.
We are really transitioning our work on environmental justice. We're really rolling it out to our government and community relations teams. So we serve 83 different counties in North Carolina, and we have government relations teams in each of those counties where we serve. And we're really focusing on those areas where we are going to be either retiring a coal facility or building new infrastructure as part of our clean energy transition, really ensuring that we're following kind of the guidance of Executive Order 246 from the governor on environmental justice, but also deploying that EPA screening tool on environmental justice. But we believe it really begins in those communities. And so we're going to be looking at creating, I'm going to call them like local environmental justice advisory councils, and really working because every community has different needs and different implementation and infrastructure, but different parameters around. So we really want to make it more community focused. Obviously, we have overarching Duke Energy EJ principles as well, but we're really trying to focus those at the community level.
Have you had a chance to implement that concept as of yet, or is it basically conceptual?
We are beginning to implement it now. I would say we're in the very early stages of implementing it.
Okay. And is there any kind of time frame for in terms of getting it fully implemented? Because it talks about there being, training that's going to be conducted, community assessments conducted, and, quite a bit of work, actually.
Well, it's going to be ongoing.
Okay,
Correct, because we're going to be deploying new infrastructure continuously for the next several decades. So it's going to be an ongoing effort, but we want to set the framework up. I think I reference a dedicated EJ email, reporting messages, newsletters, and these advisory councils. So we want to establish the framework. So it's something that we can continue as we go into these next several decades.
excellent. That provides a little bit more information, because I was trying to see if they were going to become kind of what I call an institutional framework to work within, and it sounds like that's exactly what's envisioned. Thank you.
You're welcome. All right, Commissioner Kimmerer.
Good afternoon, Ms. Bowman.
Good afternoon.
I have two follow-up questions from Chair Mitchell's questions. And the first is about the stakeholder process. And we heard testimony earlier today about certain interveners that may not have participated in the stakeholder process. And can you explain what the company does to make sure that all potentially interested interveners or stakeholders are made aware of stakeholder meetings or engagements so that they can participate if they choose to do so?
So I think every stakeholder process is a little bit different. And I think the one this morning, I could be wrong, I think perhaps was on the rate design stakeholder process. We typically try to go broader than narrower, although sometimes you want to go narrow because it can't be as productive if you've got 5,000 people commenting on one thing. You're never going to make any type of progress. On the rate design in particular, I think we went fairly broad with previous interveners in rate cases. That's typically where we get our distribution list from things like that. And I think that's where we built upon the distribution list for that stakeholder. For the low income collaborative, that was actually a stakeholder list that this commission approved. And we didn't want it to be too broad because we wanted to be able to sign and have a productive, but we had I think a good broad perspective of different interest groups that participated in that. So I would say it's not a one size fits all. It's kind of based upon the topic that we're having the stakeholder engagement for. We certainly don't want to turn people away if they have an interest, but we don't have a one size fits all on that.
Okay. Thank you. And then my second and last question also relates to Chair Mitchell's question. And this is about, she asked you about ways in which the multi-year rate plan could help implement the clean energy transition. And and you talked about opportunities and challenges. And one of the challenges that you mentioned was what I think is a very real challenge, the permitting for new generation, for transmission and distribution. And you talked about NIMBYism and then a term that I had not heard before, banana. Yeah. But can you explain how the potential approval of the multi-year rate plan would assist with permitting? Because that's something I had not thought of before. In what way the approval of your application could benefit the permitting process?
So one way that comes to my mind is I hate that I'm using another acronym, but we call them the red zone transmission projects that y'all heard a lot about in the carbon plan. Some of those transmission projects are in this multi-year rate plan. And I think by having approval of those projects in this multi-year rate plan, it could help with some of the permitting that we may need when we go out and actually try to construct those projects.
Okay. Thank you.
Commissioner Brown-Blend.
Ms. Bowman, going back to the conversation you were having with Commissioner McKissick about diverse hiring
And you mentioned about the lineman program and trying to help there. As I understand it, I've heard it said that lineman positions are some of the last good paying jobs, especially in this state, that don't require a college degree. And we would like to see that there is a level playing field for those jobs. And I'm wondering if there's someone who has or who could, or if it's something you could consider, having someone take ownership of looking into that lineman area specifically to make sure there's not a disproportionate number of um, of diverse applicants being excluded from that pool along various stages of the way. I understand it's a sort of a graduated program. You pass certain marks on your way up to before it's decided whether you can come in and either be a Duke employee or an employee at a contractor, which is a pathway into becoming a Duke employee in the lineman field. Is that something that someone could take ownership of first to see if there is disproportionality there? And second, if there is, to understand the root causes and to remove any barriers and to be willing to make changes so that we can see a difference there.
Absolutely. I'm sure we can look into that and follow supplemental.
And I'm not having evidence or data in front of me, but I don't think it would be a surprise to find that historically those jobs have not been held by people of diverse backgrounds. And they don't look like, for example, when you go into a community because there's a power outage, if that's a low income area, I wouldn't be surprised to find that the lineman population doesn't exactly look like the population being served.
Well, and I think that is something that we are working on as well for our line worker program. You know, we got that program with Central Piedmont Community College, and it's something we're trying to help build out. Also working with high school curriculum, really trying to figure out how we can get more minorities to participate in those programs. So that is something that we can definitely look at and provide details for you on.
And I'm not one to ask or require that there be any type of a quota or percentage, but I think it's good business if to build trust among the community if they see themselves inside the company ranks.
That's right.
Also, I think it's a part of that looking at the barriers just to see if there are any gatekeeper type functions that could be removed, and it would help that situation. Also, you mentioned the sort of the recruiting and the hiring and going out, and I applaud being able to go out and you know, look to the areas where you might find this population and increase their interest, their knowledge, so that they might apply and be interested. That's very good. At the same time, there are and you mentioned that you train people to help cover gaps that would help bring them in. But I think also we realize there are a lot of people who do have the college credentials and could fit within the company. But those folks are, like other folks, there's competition for them, correct? And do you find that competition in today's landscape makes that difficult to achieve goals?
Well, I don't know that I'm the expert on that. I'd have to look to our HR and our diversity and inclusion office to get specifics on that. You know, I will know I recently took a tour of North Carolina A&T and was duly impressed with the engineers that they produce. I think they produce more engineers out of any other HBCU in the country from North Carolina A&T. And one of the things that I'm trying to work on is Duke Energy was not in their top 10 of recruiters. So I think that's something that we as a company need to be working on out there. So I think there's probably some competition, but I can talk to our D&I office in the company.
And I believe, again, I don't have the precise numbers, but I believe at North Carolina A&T, you'll find that engineering program produces a diverse group. Diverse meaning not one race necessarily predominant, but a diverse group of engineers. So I'm glad you're finding that as a worthy pool place that you might look. I think that says it, but I would encourage that the company, that the North Carolina utility have someone within who takes ownership of looking at this and making progress, because it's something that I know the company's worked on for a number of years, but I think we can definitely do better, and also in the area of retention. I don't know right off the top of my head what numbers you're filing with us about retention, but I would encourage that we also pay attention to who's leaving along the same lines that I said about there being people of excellent qualification coming out of schools. There are excellent qualifications within. Sometimes they maybe gained a set of skills because of their employment there. And it's a shame to watch them walk out without knowing that you've taken all the reasonable measures to take to keep them.
Yes.
Thank you.
Go ahead, Commissioner McKissick.
This is just one quick follow-up. It was something I intended to ask originally. In terms of the programs you have today that are looking at supplier chain diversity and workforce diversity, is, how those programs came to exist in terms of their inception, and whether there may be best practices that are out there, with other investor-owned utilities that could be brought to bear that might assist Duke in structuring or restructuring the programs they may presently have to hopefully achieve better outcomes and results. So I don't know if you're prepared to answer that today. I suspect you may not be, but if you are, then that's fine. If not, if you can include that as part of your late file exhibit, that'd be great.
We will include that. I know that there are several organizations that we do participate in to try to benchmark and gain best practices, but I don't have them off the top of my head, but we can file that as well.
That would be excellent. Thank you.
All right, any additional questions from commissioners? Questions on commissioners' questions? Go ahead, Mr. Turek.
Thank you, Chair Mitchell. Just one very simple sort of summary question for you, Ms. Bowman. So just to recap, in response to Chair Mitchell, you had an opportunity to testify a bit about the benefits of MYRP and the related challenges of annual rate cases in the absence of MYRP. You discussed PIMs, you discussed execution risks. You also discussed permitting challenging questions from Commissioner Kemmerite. And in response to other questions from Chair Mitchell, I believe you also discussed the company's stakeholder engagement that led to the stipulations in this proceeding. So sort of sum all that up, Ms. Bowman, if you could just briefly summarize for the commission why you believe the company's PBR application as modified by the stipulations in this proceeding is in the public interest and should be approved by this commission.
So, for starters, I would say I think that we presented a balanced, reasonable approach kind of to the first of its kind PBR implementation. I mentioned the intense scrutiny from the public staff, the thousands of data requests, the engagement with all of our stakeholders, where we reached over seven settlements. We really believe it's in the public interest. It's going to help us move forward with the implementation of the energy policy goals set by the General Assembly of this state. And we think it's going to help us achieve those We also think it'll be the right outcome for the financial health of the utility as well. We think it's balanced, fair, and reasonable.
Thank you. No further questions.
All right, Ms. Bowman, thank you for your testimony today. We have come to the conclusion of Ms. Bowman's rebuttal testimony. I'll take a motion from you, Mr. Durack.
Thank you, Chair Mitchell. At this time, we would just move into the record Ms. Bowman's rebuttal exhibit at the appropriate time
All right.
as marked.
That motion will be allowed.
Thank you.
All right. You may call Ms. Bowman. I think you will stay in place and we'll call, you may call your next witnesses, Mr. Durack.
Chair Mitchell, the company would call the COVID panel, which consists of Ms. Bowman, who's already up there, Mr. Nick Spiros, Ms. Leslie Quick, and Melissa Abernathy. And I'm trying to direct traffic so that Melissa and Leslie sit in the right chairs.
All right. Good afternoon to you all. Just a reminder that you remain under oath.
Ms. Bowman, you have previously testified maybe twice, I guess, so far. But just please state your full name and business address for the record.
Kendall Bowman, 411 South Wilmington Street, Raleigh, North Carolina.
And Ms. Quick, you've also previously testified and are coming up again. Please state your full name and business address for the record.
Leslie Quick, 526 South Church Street, Charlotte, North Carolina.
And back to Ms. Bowman. Sorry, I've skipped a question. By whom are you employed and in what capacity?
I am employed by Duke Energy and I am the state president of North Carolina.
And Ms. Quick, by whom are you employed and in what capacity?
I'm employed by Duke Energy as the Vice President of Customer Technology, Advocacy, and Regulatory Support.
And Ms. Abernathy, again, although you've previously testified, please state your full name and address for the business address for the record.
Melissa Abernathy, 526 South Church, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
Duke Energy Carolinas as Director of Rates and Regulatory Planning.
And Mr. Spiros, I hope that mic works for you. I think you have to actually.
It's on now. You guys hear me?
I think you have to hold it. Might want to just hold it. Yeah.
It says on.
You may have to speak really loudly or Ms. Abernathy is sharing her mic with you. All right, Mr. Spiros, technical difficulties notwithstanding, although you've previously testified, would you state your name and business address for the record?
Sure. Nicholas Spiros, business address 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
Duke Energy Business Services, Director of Accounting.
So Ms. Bowman, Ms. Quick, Ms. Abernathy, and Mr. Spiros on April 14th, 2023, did you pre-file or cause to be pre-filed in this docket joint rebuttal testimony consisting of 41 pages?
Yes.
Yes.
And I think there were some minor typographical error type corrections made to the testimony in an errata filing made on May 10th, 2023. But apart from that, are there any other corrections that the COVID panel needs to make to its joint testimony?
No.
No.
If I were to ask the panel the same questions today under oath, would your answers be the same as those set forth in your pre-file testimony as corrected?
Yes.
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 Chair Mitchell, I move that the panel's pre-filed rebuttal testimony in this docket be copied into the record as if given orally from the stand.
All right, the rebuttal testimony of DEP witnesses Bowman, Quick, Abernathy, Spiros, filed in this docket on April 14th, 2023, consisting of 41 pages as corrected on May 10th, 2023 shall be copied in the record as if delivered orally from the stand.
Ms. Bowman, did the COVID panel also prepare or cause to be prepared a summary of its pre-filed testimony, rebuttal testimony that was pre-filed in this docket on May 10th, 2023?
Yes.
Chair Mitchell, the summary was pre-filed on May 10th, provided to the commission and all parties in accordance with the commission's direction, and I ask that it be included in the record as if given orally.
All right, the summary of the testimony will be copied into the record as if given orally from the stand.
Chair Mitchell, as I understand it, all parties have now waived cross for the COVID panel. So the panel is now available for questions from the commission. I would add, though, in this regard, somewhat like happened in the company's last rate case, there appear to be some strategic cross-examination decisions being made by the parties. In the last case, it was all about coal ash. Obviously, coal ash is not really an issue in this case, and there's nothing wrong with making strategic decisions about cross-examination. But for example, to the extent that the commission questions do not cover certain subjects that we believe the commission ought to hear about, and I'm thinking specifically about some of Ms. Boswell's testimony just this past Friday, which the company believes is a little bit misleading. I would ask that we be given the same leeway that the presiding commissioner gave the company leeway in the last case, and be able to bring out these sorts of things on essentially an examination within the redirect examination, if there is a redirect examination.
All right, Mr. Mehta, I will take your request under advisement.
Thank you, Chair Mitchell.
All right, let me check in with the commissioners to see who has questions. Commissioner Brown Bland. All right. Okay. All right, I have some questions for you all. Okay. Some of these questions are actually all of these questions. I'm gonna attribute all of these questions to commission staff. So if I sound like I'm outside of my lane on some of these accounting issues, that's why. But before I get to their questions, I want to make sure I have a clear grasp on the total amount that the company seeks to defer in this proceeding. Your rebuttal testimony indicates 95 million. That's somewhere. I had the reference here. And I believe that was year end. So can you all help me understand where we are now?
So I can help with that.
Okay.
On page 21 of our testimony, there's a table that summarizes the total requested deferral amount, and that was actually as of our second supplemental filing. So you'll
Okay.
see 93 million of cost, and then carrying costs and 105 million is the total amount. That has subsequently been updated in our third supplemental filing to approximately 107 million, mainly because the amount of bad debt expense increased.
Okay, so what was the 95 million? I may have just misread that.
I'm not sure.
Okay, but your testimony is we're at about 100. You're at about 107 today, or as of the third update, the third
Correct.
supplemental
As
update.
of the third supplemental, we're at
Okay.
107 million. And then we also have the request to continue to defer bad debt expense.
Understood. And the revenue requirement associated with the deferral is around 41?
Yes,
And
approximately that amount.
assuming amortization over a 3-year period.
Yes.
Okay. And how much does that revenue requirement move based on the third update?
Not significantly.
Okay. Okay, thank you, Ms. Abernathy. All right, we understand that the impact of COVID on the financial performance of the utility may be like anything ever, may be unlike anything ever experienced. Do you know if there are any new FERC accounts available to track costs and lost revenue resulting from a pandemic-like public health situation?
Not that I'm aware of.
Okay. Has the company set up any new general ledger accounts to track costs, revenues, and savings that may be related to or caused by the pandemic?
Once again, not that I'm aware of, no.
Okay. Does the company have a structured and well-documented approach for identifying, measuring, and tracking COVID-related impacts?
I believe we do, yes.
Okay. In the company's partial settlement and agreement, Exhibit 4, Adjustment Work Paper NC 5090-2, COVID deferral detail, and I'll give you a minute to get there in just a minute, but let me ask the question. COVID deferral detail, column B2, line 34, NC retail incremental bad debt in September 2022 was approximately $12.5 million. Does this sound correct to you all? And Ms. Abernathy, I'll give you that reference again. Exhibit 4, Adjustment Work Paper NC 5090-2.
Are those Ms. Jiggett's exhibits?
Yes.
I'm not sure I have that here.
Chair Mitchell, are you reading from the settlement package?
Well, I'm reading from my list of questions, but let me go to Ms. Jiggett's testimony and see if I can find it.
I mean, I can get Ms. Abernathy the settlement package,
Okay,
which is the
but
final.
before you expend that energy, let me just go there.
I think I may have, did you say column B2?
B2, yes, ma'am, line 34. NC retail incremental bad debt, September 2022.
Yes, I see 12.4 million.
12.5 million.
Yeah,
So
12.5.
does that seem correct to you?
I believe so. Mr. Spiros can talk a little bit more about our bad debt expense, but what we have included in this column is we are looking at any amounts that are above what is currently in rates for bad debt expense. But our bad debt expense has continued to increase throughout this period, as Mr. Spiros can probably add to. So these numbers come from his team, so he could talk a little bit more about that.
Okay, here's the reason for the question. This amount, which is a 1-month amount, is that correct? It's
Yes.
about 1/5 of 3 years total bad debt expenses identified by the company. So it seems like an outlier to us. And so we want to make sure we're understanding that number correctly. And if it is an outlier, help us understand why.
So there's two components of bad debt expense, your actual charge-offs from the subledger system, and then you have a reserve adjustment based on the level of accounts receivable. I can't remember specifically if September of 2022 we made a reserve adjustment, but if we did, that would be a level of expense on top of what was charged off for that month. So it may look elevated in comparison to other months.
Can you help me understand what a reserve adjustment is exactly? Explain that to someone who is not an accountant.
I will do my best. So charge-offs are when a customer doesn't pay and we have that expense hit our ledger. Every quarter we analyze our reserve, which means we look at our accounts receivable at any point in time, and we need to put in a reserve against that accounts receivable to essentially state the expense against the revenue that we're recording. So in a nutshell, that's essentially what we're doing is we're recording that expense today with the revenue and estimating what we expect it to be in the future.
Okay. All right. Thank you for that explanation. Okay. So you're not certain, but you're assuming or you're speculating that there may have been a reserve adjustment in this month, which makes the number appear to be an outlier. Okay.
Yeah.
All right, page 11 of the panel's rebuttal testimony. You all indicate that several state commissions have begun to allow recovery of deferred costs, and you reference the Georgia PSC. Are you aware of any other commissions that have taken action on cost recovery associated with deferred COVID expenses?
Not off the top of my head. I think we are aware of a lot of states that have allowed the deferral, but not specifically addressed the recovery.
Okay. I think in Ohio and our Duke Energy Ohio, they received the deferral, but the commission instituted a bad debt expense recovery rider. So I think that issue's been taken care of in Ohio. Okay. All right. So testimony on page 23, you all indicate that 90% of the deferred costs are attributable to waived customer fees and increased bad debt expense. Regarding the waived customer fees on page 25, the panel states in response to public staff data requests, the company also provided the methodology as to how the company calculated the incremental late payment fees, returned check fees, residential convenience fees, and walk-in payment fees that it deferred. You further state on page 25 that the public staff did not appear to use this information in its testimony. Can you explain the methodology that you all used? And is there any work paper or other type of late filed exhibit that you all could provide to help us understand the company's calculation of this amount? If you need me to restate the question, I'm happy to.
So as far as the methodology, I believe we used our customer information systems to understand kind of which customers would have had late payment fees and those types of fees assessed upon them. And using that information, we're able to estimate the amount of fees that would have been charged to customers. As far as work papers and things like that, I'd have to look back to exactly what we provided, but we had details of all of the calculations of these amounts and the amounts that we have deferred that we were provided.
That you provided to the public staff?
I believe so in Discovery.
Okay, and is it it's your, as I understand your testimony, the public staff did not take that information into account, is that correct?
They had, they didn't really actually say anything around the amount of waived fees that we had in the deferral. They've just recommended to disallow the entire deferral.
Okay, and do I understand, Ms. Abernathy, your testimony correctly that the customer information system can identify for the company which customer would have incurred a fee had you all been imposing fees at that time?
That's my understanding on how we received the data. It came directly from our customer team.
Okay, is there anyone on the panel that can confirm that?
That's confirmed. Yes, it comes from our billing system.
Okay. All right, on page 12 of the testimony, you state that the public staff ignores revenue loss entirely. And you state on lines 15 through 18 that when faced with a prospect of revenue loss, the company is a routine part of its business and in keeping with its focus on managing O&M costs for the benefit of its customers, identifies and implements a suite of cost mitigation measures. The panel states on page 34 some of the expense mitigation measures it employed related to lost revenues due to weather and other factors. All right, so on page 34, the panel generally talks about mitigation measures related to COVID NLRs and weather NLRs together as factors affecting revenues. Did the company quantify net lost revenues due to the pandemic only?
So yeah, we have quantified net lost revenues, and I talked about this, I believe, on page 35, so around there, that we have been able to quantify total net loss revenues for North Carolina retail for 2020, which is to be approximately $71 million. And using our accounting records, we can see, analyze that and know that portion of that is related to weather, like what would have been weather normal revenues. And then another portion is just related to reduced load and demand. And so for purposes of this analysis, we've assigned the kind of non-weather impacts of that to be related to the pandemic, which is about approximately $28 million. I believe I cite that also. I believe I cite it somewhere else in the testimony, the $28 million that's directly related, that's related to COVID.
Okay.
That's on page 30.
Okay. Okay, so those NLRs are pandemic related, and the NLRs specifically referenced on line 20 are COVID related NLRs. Just making sure I understand you.
Yes,
correct.
of the
Okay.
71 million in net loss revenues for 2020, we're estimating approximately 28 million of that is related to the lower load due to the pandemic, whereas the remainder of that would be related to weather impacts that were impacting revenues as well.
Okay, thank you. All right, would you all agree that some of the cost savings incurred by the company related to COVID were not related to mitigation measures enacted by the company? For example, reduced employee expenses due to travel restrictions, and reduced printing and postage due to not disconnecting customers were a result of government imposed actions. Also, the savings you discussed beginning on page 31 related to delayed Social Security tax payments and employee retention credits. These were not mitigation measures taken by the company. These were also outside of the company's efforts to control costs. Would you agree with those statements or?
So I would agree that the company has tracked savings and we've identified types of savings that we believe are directly related to COVID. And those are primarily in the employee expenses bucket, because we didn't have employees traveling, we didn't have employees meeting or going to conferences, in-person meetings, things like that. So we have identified those savings as being related to COVID because of all of the travel restrictions and other things that were in place. In addition, the printing and postage. There are some other benefits that were available to us, primarily these tax benefits through different federal laws. One that cited the AMT, I think is important to point out that none of that was related to Duke Energy Progress. Any of the AMT refunds or credits that we were able to accelerate, all of them were related to other affiliates. So none of those related to Duke Energy Progress. Duke Energy Progress was able to delay some of the Social Security tax payments per that rule, and then also apply for the employee retention credits. It took a little while to identify, get all the paperwork submitted for those employee retention credits. We've since done that and been able to quantify an amount that is related to that federal CARES Act.
Okay. Would you say, Ms. Abernathy, that those savings achieved that you've just described occurred outside of the company's effort to control costs and were one, outside of the company's control, and two, were due to the COVID pandemic?
I definitely think they're due to the COVID pandemic. I do think employee expenses could be a little, we can control that at times, but the primary driver of why we had savings was due to the restrictions placed on travel and things like that.
Okay.
But I would add, we did have costs in light of the pandemic. Unlike other industries that send everybody home, 40% of our workforce had to continue to work. We had to continue to keep the lights on for everybody during the pandemic. So we had the line workers out there, we had the employees out at the plants. So we had a significant amount of our workforce that continued to work. We also had
And Ms. Bowman, let me interrupt you right there. Did that significant amount of your workforce have to continue to work in part because this commission, you all were directed to continue service even in the face of non-payment?
No, it was to provide electricity.
Well, I'm sorry, to provide electricity, but even in the face of non-payment, you were
Even-
still having to send your people out and
Yes.
provide service as if you were receiving payment for that service.
Yes,
And did you ever stop providing service? Did you ever make a decision to not provide service because you were faced with the prospect of not receiving payment from certain customers?
No, we did
And,
not.
and you continued to provide service dutifully and as directed by this commission and as required to do under federal and state law?
Correct.
Okay. Was there ever any internal discussion about ceasing to provide service in spite of all the challenges that you were facing, not the least of which was non-payment, the potential for non-payment from certain customers?
No, we are.
Did you continue to provide
Yes,
service?
we continue to
And,
provide service.
and how long did that how long did you all continue to provide service in spite of all these challenges, not the least of which was non-payment for the service that you were having to provide from certain customers?
The entire time.
Can you give me a sense of how long that lasted?
Well, I would just mention the state of emergency governor's order, which lasted from March of 2020 until August of 2022.
Okay, and help me understand sort of does that mean that you were having to send people out into the field? You were having to in spite of the pandemic that was ongoing and put them in harm's way?
Yes, I mean, we had to ensure safety protocols were in place. We had to go get protective gear, face masks. We actually had one of our nuclear facilities that actually made and produced hand sanitizer.
Mhm.
Along the way, we had to install, the barriers at the workstations at a lot of our operating plants, so employees would not transmit viruses. I know in some circumstance at our operating control centers, we had several operators that didn't leave, that had to stay in the facility so that we could ensure that lights stayed on throughout the pandemic.
And have you ever been ordered by the commission to provide service, by this commission, the North Carolina Commission, to provide service, regardless of whether you were paid for the provision of that service?
I mean, we are statutorily required to provide.
Well, but I understand that, but has this commission ever ordered the company to provide service even when you're not receiving payment for it?
Well, believe we didn't, we had to waive non-pay disconnects, and so we continue to provide service in this
Right.
context.
Right. Okay. Any other questions from commissioners? Go ahead.
I have some.
Actually, I'm gonna do a little, you can ask them and I'll follow up.
So following along those lines, the costs that were incurred that have been deferred were not discretionary on the part of the company.
That is correct. The, waiver of the non-pay disconnect and all of the fees associated with it. I think say 90% of it was due to governmental mandates or commission orders.
Okay, thank you. And so I heard witness Boswell testify that the main reason public staff has recommended disallowance of the deferred COVID costs was because the public staff could not discern the company's offsetting savings resulting from the pandemic. Did you hear that testimony yesterday or the day
Yes.
before? And but then the sense that I obtained from the testimony was that the public staff was not opposed to the recovery of deferred cost if that offsetting savings could be determined with the company. Did you hear that testimony?
We did, and witness Abernathy can go into more detail, but we believe we've provided the savings. We believe we've tracked and provided that information. I think it is more of an interpretation difference that the public staff has with what we proposed in this case.
And she seemed to indicate that, and attorneys, tell me if I can't ask this question, but she seemed to indicate that there was ongoing discussion regarding trying to resolve this offsetting savings amount.
I'm going to turn to witness Abernathy.
I'm not aware of ongoing discussion. We did provide had many discussions throughout the discovery process. We provided a lot of data that I've laid out, different types of data around full AVBs for the different years that show savings. as well as full details of all of the cost and our view of the direct savings directly attributable to COVID. We provided that in various forms of, or various levels of detail to the public staff. So I believe they have everything that we have with regards to what savings we did realize in 2020 and beyond.
Okay, thank you for that. And then the one other issue that I heard from the public staff, or the sole other issue, was with respect, and it goes to the savings or the stipends that were provided. Could you please outline your response to the public staff's concern as to the stipends?
I'll start, and then Witness Quick can kind of fill in where I leave off. I think their concern was that was, not a governmental mandate, or a commission mandate that we issue stipends to our employees, but recognize we were in the context of a pandemic, and we needed to retain our employees. And a lot of the employees at the call centers were transitioning from used to working in person with computers set up and everything to working in a home environment. They could not stop. We had to continue to take customer calls throughout this time frame. And they were struggling with childcare, Wi-Fi connections. And so, the company felt in order to retain our quality employees that we would offer a stipend kind of based on,
Their
hourly wages. And so when it's quick, you can provide more details there.
I think you did a really good job explaining that. But at the beginning of the pandemic, obviously, we wanted to continue answering customers' calls. And they had been serving their job and their roles in call centers. And so the company was actually able to make it happen that our specialists were moved into a remote environment, a virtual environment, within 2 weeks. And that, of course, created a lot of probably concern and uncertainty for our specialists. I mean, they're at home, maybe smaller homes, maybe apartments, don't have office equipment or whatnot, they don't have internet, et cetera. And then they have small children. But we needed to retain them. And this was just a little something small that we could do to try to keep them and help them through this unprecedented time that we were all going through. So it was just a way of really supporting our hourly employees at the call center.
Okay, thank you. And it's my understanding the company's position on the years of amortization is 3 years. And you've probably heard me ask Witness Boswell what the public staff's position was with respect to amortization. And I believe her response was 10 to 15 years. And do you have a response to that 10 to 15 year time frame?
I would say we would be probably willing to extend it a little bit longer. We would prefer to keep it in the increment of 3 in light of the multi-year rate plan. Maybe 6 years. I know some, trying to remember. Somebody agreed to 5, maybe I'm dreaming
It was
that up.
Texas.
Maybe somebody agreed to
years.
5. I dreamed it up in my head.
No, it was Texas agreed to 5-year amortization. Okay. Texas case. Okay, thank you.
Can you all, so can you just walk me through so that I can understand, or at least attempt to understand the need for the continuing deferral of the bad debt expense? Ms. Abernathy, maybe this is where you can help. What necessitates that deferral? Why is there continuing? Well, let me just stop asking the question. But what necessitates the deferral?
You want to take it, or you want me to? Well, I might guess, so I might be wrong. So y'all correct me if I'm wrong. But if you recall, Chair Mitchell, throughout this proceeding, we've communicated, we filed things regarding the disconnects, and then we had a long discussion about payment plans. So we instituted fairly long payment plans in agreement with the public staff, the Attorney General. We worked with the Justice Center, really as a way to help our customers that were struggling, long payment plans. Well, we see ourselves now coming kind of to, the point where those long payment plans are finally getting there. And so we're still continuing to accumulate bad debt. So I think it's these lengthy payment plans that are likely the reason we need to continue that. But y'all tell me if I'm wrong.
But Ms. Bowman, just following up there, so you've put the payment plans in place and they're X number of months. And so is the company experiencing non-payment of those payment plans? Is that what's happening?
Yes, so let me maybe take you back just a little bit. So as an outcome, in the docket 100 sub 158, we were ordered to suspend disconnections from March of 2020 through September of 2020. And at the end of that, we were required to offer our customers at minimum at least one 12-month payment arrangement. And so during this time, we've been extremely flexible with our customers because, maybe 4 months down the road, they couldn't make their payment. And so we said, can you make your current bill payment? And then we reestablished our payment arrangements, which has led to these higher arrearages that Nick has spoken about earlier. The other thing we did too, as part of the really trying to help our customers out during the pandemic, is we expanded the winter moratorium. And so that really enabled us to support and suspend disconnects for non-payments for about 50,000 of our DEP North Carolina customers from, let's see, November 2021 November 20 until March of 2022. And at the end of that March 2022, we also, as part of docket 100 sub 158, we also enrolled those customers into 12-month payment plans. So you can just kind of see that the flexibility and what we've done to really support our customers in need to give them more options to make a disconnection for non-payment a last resort. And that's kind of led to these higher arrearages.
Okay, and so just okay, I think I'll stop there. I think I understand. So if
Can
we
I add one thing on the level of bad debt expense and
Please.
what we have requested in the case and why we have continued the deferral? So we were deferring bad debt expense in the test period. So the amount of bad debt expense that is included in our revenue requirement is at the same level of bad debt expense that we were experiencing in the last case. We've also have our deferred bad debt expense that's over that amount. And so we've requested to continue that deferral because we know that bad debt expense is higher than it was in the past case. But we haven't seen the completion of the payment plans, the completion of all that to know what is the appropriate level of bad debt expense going forward. So we've kept it at the same level that's currently in rates, which is why we've requested to defer it. If we weren't requesting that, 22 alone had nearly $50 million in bad debt expense. And so we'd have to increase what we have in our revenue requirement for the test year by about 42 million to cover what we actually know bad debt expense to be for 2022. But we just don't know how the payment plans and everything will work out in the future to know what's the proper level going forward for bad debt expense.
Okay, that's very helpful. Thank you for that explanation. Ms. Bowman, your response to Commissioner Duffley about the savings, I understood your testimony to be in response to her question that you all did measure savings and you provided that information to the public staff. And you indicate, I believe it's in your pre-filed testimony, there's a fundamental difference of opinion or disagreement about the savings. Can you say a little bit more about that difference of opinion?
So I think that the public staff is viewing when we implemented a lot of our routine O&M savings whenever we get into situations for like mild weather or whatever. We institute, again, the company's well known for this kind of O&M savings. We call it tightening the belt, so to speak. I think the public staff viewed those as things that should have counted for COVID savings. And we do not believe those things should count for the COVID savings. Those were done in routine course of business. Ms. Abernath, is there anything you want to add?
No, I don't think I'd add anything there. That we did, implement a series of routine cost cutting measures to address not only COVID impacts, but also mild weather, increased storm costs, things we do in normal course of business when faced with revenue pressures. But we did identify some of those savings that were directly attributable to COVID in the form of saving on employee expenses and then the printing and postage. But those offset the significant net lost revenues that we experienced because of COVID, or the net lost revenues significantly offset those direct COVID savings.
Okay. All right, thank you for that additional explanation. All right, any additional, oh, Commissioner Kimmerer.
And to follow up on Chair Mitchell's question, when you related to the offsetting of the savings and this kind of fundamental disagreement about what the savings should be, did you very clearly differentiate between the COVID savings and then these tightening of the belt types of savings in the documentation that you provided to the public staff?
We believe we did.
Okay. And can you just to make it very clear, can you explain the public staff's position about why they think that your specific COVID savings that do not include those tightening the belt types of savings should not, that they disagree with that? Can you provide your understanding of their position about that and your response?
Gonna lean on witness Abernathy to help me here.
My interpretation of their view is that any savings we were able to realize in 2020 were because of COVID, which is not true. We had savings because of employee expense savings due to the travel bans and reduced expenses there, as well as the postage savings. And those are the savings we have attributed directly to COVID. We also implemented other savings measures in 2020. And those are the normal routine types of savings that we would do to lessen O&M when faced with revenue pressures.
Yeah, I just wanted to make it clear that you were not attempting to recover those savings in this docket, these tightening of the belt types of savings.
No.
Okay. And then one last question about follow up from Commissioner Duffley's question about the stipend, the one-time payment. And I believe that the public staff stated on page 43, which I don't think you really need to go to the testimony, but one of their objections to the stipend payment was that the company did not verify the stipend payment. Can you respond to that concern? It's actually on page 43, line.
And our response is that to go through the effort to verify the way those were used would just add additional administrative costs to check receipts and do all of the reporting. So we did not verify those expenses. I don't know, Leslie,
Yeah,
do you have anything?
and those are the stipends that I talked about earlier, where we
Correct.
gave our call center specialists or our hourly employees the stipends. And at that time, everyone had different needs. I mean, from an employee perspective, family perspective, internet perspective, maybe they needed an office chair, we gave them like laptops and of course their monitors and stuff, but there were needs that they needed during this time. And so we gave them the flexibility to spend it on whatever. And we did not collect each individual receipt related to those expenses.
Okay. And then the last question is on, again, page 43, and it states, if the stipend were to be allowed and the deferral by the commission, it should at a minimum be offset against the federal tax benefits the company received for giving the stipend. Can you respond to the public staff's concern or statement in that regard?
I'm sorry, can you repeat your question?
Yes. So can you respond to the public staff's statement? And this is on testimony on page 43, and I'll just read it to you. If the stipend were to be allowed and the deferral by the commission, it should at a minimum be offset against the federal tax benefits that the company received for giving the stipend. Can you just provide a response to that concern?
I think we view any of the tax benefits that we were able to receive as, potentially other COVID savings that we would say even when added to the employee expense savings and postage savings we have identified, we still have not been able to offset the net lost revenues related to COVID. So we would bucket that with the savings and say that we still haven't offset the net lost revenues as opposed to applying it against the cost.
Okay, thank you.
I would just reiterate the bulk of the dollars are really the bad debt expense and the customer fees waived.
Commissioner Brown Bland and then Commissioner McKissick.
All right. I just have a state of confusion and I may be replowing a little bit of old ground, but my sense from witness Boswell and or her panel was that at some point she testified that the company just didn't keep the saving records that she was looking for, which implied to me that there had been some request for information specified in some manner and asked for to have been kept in a certain manner that they were not able to receive, that they had received an answer that the company didn't have it. Now, what they asked for, as I understand, there may be disagreement between the company and the public staff to whether it bore on this issue or was relevant. But do you understand that portion of her testimony, if you agree or you heard something like that? And was there in fact information that the public staff was seeking that the company said the company didn't keep or didn't maintain as they were going through the COVID experience?
We believe it's really that difference of interpretation. We believe that we submitted what we believed were the costs to the public staff, and that it's a difference of interpretation on these other O&M savings that we just had the conversation about.
So was there a response to the public staff that you didn't have what they were asking for?
So we did provide the details of the savings directly attributable to COVID. We provided how we calculated the employee expense savings and the postage savings. And in addition, we provided a pretty detailed explanation of full AVB explanations for all O&M for those years. We just don't see the rest of those O&M savings as being directly related to COVID, but we provided a full accounting of AVB results for 2020. And in multiple levels of detail, I believe, and then also the support for our savings that are directly attributable to COVID.
So there was not information they sought that you could not provide because you didn't keep it in the manner that they wanted you to, or?
I believe we provided support for the savings that we identified as being COVID-related savings.
Well, for the support as you saw it, but if they were asking and they felt that they needed something for their to have a complete informed position on the topic, were you able to give them that information? Or was rather than to say were you able to give, was it information that you said you did not, that the company did not have and therefore could not provide?
Yeah, I would say this, we provided a full accounting of our actuals versus budget to the public staff. And from an actuals versus budget analysis, you can inform from that analysis what those variances are related to. So we believe we gave them everything that they needed to make an informed judgment based on those variances.
That they needed, but I'm asking that they asked for. What about that?
Again, we gave them a full accounting at a detailed level of every expense that's on our ledger for those years.
All right, thank you.
Yeah.
Let me follow up briefly on that matter Commissioner Brown Bland was mentioning. And I'm looking to page 24. And the question raised on line 15 was, did the company track the incremental costs related to COVID-19 and provide sufficient detail to the public staff to audit the cost? And there is some information provided early on, but if you look at the last line and the response here, on line 22, it says, as a result, the public staff requested supporting documentation for 66 invoices in response to a certain document request. and the company provided the invoices and supporting documentation to the public staff for audit and provided responses to the public staff on those questions to allow the public staff to determine reasonableness and prudency of the costs. Now, were you all feeling as if everything that had been submitted to public staff was reasonable, that was adequate, that was necessary to make appropriate determinations, or was the public staff still in a position to say we need more further additional information? Because I gather public staff would contend that they were not completely able to, based upon the documentation provided, to make appropriate determinations.
I think we believe we provided them reasonable documentation to conduct their analysis. I'll go back to, I think it is this difference of interpretation.
And I don't recall where I read it, but it seems that at some point there was reference to South Carolina and what was done there in terms of these COVID-related expenses, where I guess what was being requested for deferral was also there was information provided related to savings that were taking place contemporaneously or something of that effect. Do you recall that information? I believe it was in the rebuttal, but I'm not sure if I read it elsewhere.
We filed reports with the South Carolina Commission on these.
Yes, the South Carolina Commission asked us to provide quarterly reports
That's what it
detailing
was.
our COVID cost and COVID-related savings, which is why we started tracking those direct COVID-related savings in the form of employee expense savings and postage. And so we've been reporting that I believe it's quarterly, to South Carolina.
Okay. And what action is South Carolina taking at this time, if any, other than just receiving that information?
So they received that information. I do not believe there is a deferral in South Carolina. If you recall, differing circumstances, South Carolina did not have a state mandate the way that North Carolina did. So it's not an apples to apples comparison. In that vein, I will also share, when I listened to Witness Boswell, I don't think she painted a complete picture. I think she mentioned something to the effect that DEP was the only utility requesting COVID deferral cost. I think it's DEC and DEP, but I think you need to look at the context and the size of DEC and DEP. We serve 3.2 million customers. The other electrics in the state of North Carolina are much smaller. The gas utilities actually have, I think, things in place. I'm not sure if I'm going to get it right. A purchase gas adjustment mechanism that allows them to reduce exposure to earnings degradation kind of automatically. I know Piedmont has this. I think PSNC has that as well. We did not have that at our disposal. So I think, Duke Energy Carolinas and Duke Energy Progress, for our size, we have a significantly more bad debt out there and late fee payments out there as well.
Okay, and I suppose that, of course, the public staff says that there was 96 million savings in 2020 and 23 million in 2021 due to COVID. But I guess your contention would be they didn't take into consideration net loss revenues as well as other factors.
That is correct. And we are not asking for recovery of lost revenues.
Thank you.
Questions on commissioners' questions? Let's start over on this side of the room. Yeah. Questions from public staff?
Nothing.
Company?
Just a few, Chair Mitchell. You all were asked a lot of questions about the discovery process and information supplied to public staff in that process. I will ask first, though, Ms. Abernathy and Mr. Spiros, if you heard Witness Boswell say that, in her opinion, the company meticulously tracked costs associated, that are in the deferral. That is, they don't really have a problem with the costs in the deferral.
That's correct.
But I guess the basic divide, and as you call it, the fundamental disagreement, is that the public staff says you should have offset those costs with savings, and the company's position essentially is, if you do that, you also need to offset them with net loss revenues, and if you do that, the revenue impacts completely outweigh any savings. So I wanted to explore with you a couple things. One is the volume and amount of information that has been provided to the public staff, but also the way, and I think you may have hit on this, Mr. Spiros, a few minutes ago. The accounting system is really good at tracking costs, right?
That's its intention, yes.
It can't directly track the negative, track a savings directly.
That is correct.
In order to get a sense of savings, what you need to do is track, or not track, but compare what you actually spend, which is tracked, with what you thought you were going to spend, which is sort of baked in pre the spending, right?
Yes,
And is that what you mean by an actual versus budget comparison?
that's exactly what I mean. Yes.
And when you do that, you get a sense of what the company didn't spend that it thought it would spend, right?
Yes.
And can you make a judgment based on what the type of expense actually is as to whether or not the expense is a COVID-related expense or not a COVID-related expense?
Through analysis, yes, you can.
And is that essentially what the company did in order to figure out that these employee, reductions in travel and those sorts of things, and the postage and paper expense could be classified as a direct savings from the COVID pandemic?
Yes, it is.
And is that what you actually did in order to figure that out?
Yes, that's exactly what we did.
And Ms. Abernathy, I think you indicated that South Carolina required that information to be filed with South Carolina. And is that the information that was filed with South Carolina?
Yes, we use the same information.
Now, in the course of this discovery marathon, did the company provide the public staff with detailed budget to actual cost information?
Yes.
Yes, we did. And it's everything, examples of what we provided is all laid out in our testimony at pages 25 and 26.
Well, walk us through what's laid out on pages 25 and 26 and just how it relates to the issue of what did we spend? What did we think we were going to spend? How much revenues did we not get? All of those factors that are factoring into this basic divide between the company and the public staff.
So as far as the data on page 26, it lists the different types of data that we've provided. So we have detailed listings of general ledger accounts by month for the actual COVID costs that we've deferred, both at a system and an NC retail level. We've done that for all the costs that we incurred in 2020, 2021, and 2022. We've also given a detailed listing and applicable general ledger account by month of any of the COVID-related savings. So we showed how we calculated that AVB for employee expenses, as well as postage, print, and savings. We gave that for.
Ms. Abernathy, I hate to interrupt you, but when you say AVB,
actuals
probably maybe 3 people in the room know what you're talking about.
Accountant talking. So actuals versus budget that show the savings that we had for employee expenses. Additionally, we gave actuals and budget information for 2020, 2021, and 22 for operating revenue, our revenue from non-utility operations, a lot of information on that. We gave a comprehensive analysis of actuals and budget information for O&M by function for 2020. We also gave actuals by month for several years, 2018, 2019, 2020, 2021, and 2022, with GL account information for various categories of expenses that are laid out here, as well as any costs that were allocated to DEP from the service company. They did make selections of some of the costs that we've deferred, and we gave all the support for all of the selections that they made, as well as any of the journal entries that we made. So that's a summary of all of the data that we made available to public staff through the discovery process.
And Ms. Abernathy, you should have an exhibit binder in front of you, probably a couple of them. But the one I'm looking for is the DEP potential cross exhibits.
Got it.
And look, if you would, at DEP potential cross exhibit 17. Or actually, it may be a redirect exhibit that I'm looking for. Just a moment. No, potential cross exhibit 17.
Yes, I've got it here.
And that's an email chain between the company and the public staff, correct?
Correct.
Chair Mitchell, I'd like to go ahead and mark this document, DEP potential cross exhibit 17, as DEP redirect COVID panel rebuttal exhibit 1.
Document will be marked DEP redirect COVID panel rebuttal, exhibit number 1.
And Ms. Abernathy, not to go through the entire email chain, but the email chain is actually outside of the discovery process. So were these communications and conversations with the public staff also going on outside the formal discovery process?
Yes, they were.
And Mr. Spiros, if you would just look at the final 3 pages of this exhibit, just tell us what this is.
This is the detailed actual versus budget analysis by function and resource type for fiscal year 2020.
And how does that relate to the issue of tracking savings or tracking costs?
Again, this is a full accounting of all of our O&M expenses versus what we expected to spend. And it has the variances by function, and somebody could make an informed judgment on each one of these variances.
Ms. Abernathy, I mean, you've walked us through some of the discovery responses that were made. We've seen this exhibit that shows efforts that were made outside of the formal discovery process. I mean, did the public staff use any of this data to provide an estimate of what it thinks COVID savings might be?
No, they have not.
And Ms. Abernathy, in fact, if you look at all of the data or the description of the data requests that you have on pages 26, 27 of your testimony, I mean, from your perspective, did the public staff use any of this data to engage with what the company was actually experiencing during this whole process?
No, they did not.
So bottom line, if the public staff's position is they were not provided with sufficient information to assess, just even assess the company's request, and therefore recommended denial of that request, you don't agree with that position, do you?
I do not agree with that position.
Is the public staff's position in this case essentially the same as the public staff's position that it took in the COVID deferral docket?
I believe so. I believe they were opposed to the COVID deferral. And then they're opposed to recovery of these costs here.
Now, Ms. Abernathy, on page 36, I think it's line 6 of your testimony, you noted an estimated 62 million of savings on an NC retail basis, correct?
Yes.
And that number includes the employee savings and the postage paper savings, those sorts of costs. But apart from that, those particular costs, that's the belt tightening savings, correct?
Yes, this is using the 96 million of total savings that public staff referenced, and that the 62 million is a North Carolina retail version of that and represents all savings for 2020.
And these are the savings that, again, apart from the employee expense and the postage and printing and paper costs, these are the savings that the public staff says, well, all of them have to do with COVID, and the company's position is no.
Correct. These are the savings that we were able to implement and we were able to achieve, not only to address the impacts of COVID, but also to address the impacts of mild weather, increased storm activity in this year. And I kind of lay that out here in this testimony. You know, I've referenced the $71 million of net lost revenues. That's a combination of impacts due to mild weather as well as COVID. Then in addition to that, in 2020, we had higher than normal storm expense, not quite to the level where we could request deferral, but we still had more storm expense than we had expected. And so, as is our normal course of business, we implemented these cost efficiency measures to address those impacts to our company. And we were able to achieve $62 million in savings on a North Carolina retail basis. But that did not offset the 85 million of negative impacts to the company, which includes the net lost revenues and the increased storm cost. So we were left with a $23 million shortfall for 2020.
Thank you, Ms. Abernathy. I'm going to switch gears on you. And I think in response to one of Chair Mitchell's questions, you indicated, this was the question about the continuation of the deferral.
Yes.
And actually, this may be either Mr. Spiros or Ms. Abernathy. I believe Ms. Quick said in March of 2022, when the winter moratorium sort of finally, the extension of the winter moratorium that had been in place now for many, many months had bled off, the company entered into 12-month repayment plans with people who needed the 12-month, or actually automatically enrolled people in 12-month repayment plans. Do you recall that testimony?
I do, yes.
12 months from March of 2022 would be March of 2023?
Yes.
And are you seeing even today elevated levels of bad debt expense?
Yes, we are.
Which are not, Ms. Abernathy, in this case, correct?
No, they're not. We still have, in this case, the level of bad debt expense that we were experiencing in the last rate case, since we've been deferring any incremental amounts.
And I think you testified in response to one of Chair Mitchell's questions that if you were to not, if the commission were to not grant the continued deferral, you would see an increase, and we ought to then account for that increase in this case of increased bad debt expense, correct?
Correct. I think if we were not requesting continued deferral, we would need to increase the test year level of bad debt expense by approximately $42 million to represent what we've actually incurred in 2022.
And that would mean that the revenue requirement in this case would increase by that amount, correct?
Yes, related to what we have for bad debt expense.
All right, Mr. Meta, I'm going to stop you right there. We'll resume with questions on commissioners' questions tomorrow, and I can't promise you that there won't be more questions from commissioners. So see everybody tomorrow at 9:30. We're off the record.